And we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting in diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am lucky, and you are lucky. I'm joined today by two outstanding colleagues, Justice Sachs and Justice Ditkoff. We apologize for the delay in getting started. We've had some technical difficulties with respect to our Zoom and streaming technologies, which I have to say such difficulties have been rare over these past months. So they're bound to happen sometime, but we do apologize for the delay in getting started. We are holding this hearing by teleconference rather than in person due to the ongoing pandemic. The rules for argument are the same here as they are when we are live and in person, which is to say 15 minutes per side and no rebuttal. In this case, one attorney, an attorney for Mr. Chapdelaine, will not be arguing, but will be available for questions at the end of argument time, should we have any. The first case we'll hear today is number 20-65, Constantino versus Chapdelaine and others. And we will hear first from you, Mr. Traft.
Good morning, Your Honors. Attorney Michael Traft on behalf of Robert Constantino. I first want to address the issue of the awarding of costs pursuant to 118E Section 44. And I want to start off by agreeing with the Commonwealth that this is a separate proceeding from an award of fees under Section 6F. But that doesn't mean that Mr. Constantino lost because or waived it because he didn't raise it when he pursued an appeal of the underlying judgment. It's the exact opposite. The Commonwealth has waived their right to raise this issue by not raising it at the time of the original litigation. This was only asserted in the context of a hearing on 231-6F. This is post-judgment. The judgment had entered 5 months before that, and there had been an order that payment be made within 60 days. On the morning of the first hearing on this, the judge granted that order to sell the property that has been held by Mr. Constantino to satisfy the Commonwealth's lien. By the time of the second hearing, Mr. Constantino had, rather than having the property sold, had paid the debt. So before, in fact, months before the order ultimately came down, this judgment had been over and satisfied. So the Commonwealth, and they only raised it in the context of this hearing as an afterthought, on redirect after all the testimony by the witnesses at the hearing. The Commonwealth says, oh, by the way, is there some other way that the Commonwealth could get money? And they said, yes, with Section 44, we can have costs. And the other parties objected to say this is too late. And the judge overruled that objection.
Counselor, be that as it may, the case law says that if you have something that's appealable both to a panel and to a single justice, you have to file 2 notices of appeal, and your client filed 1. So that notice of appeal, is that appealing the 6F fees or is it appealing the 118E costs?
It's appealing both orders because this is a one order, an order by the judge to award costs pursuant to the terms of that section. Now, 6F allows an awarding of costs.
We said in Bailey that even if it's one order, you have to file 2 notices of appeal, one to the single justice and one to the panel appeal. And we've got 1 notice of appeal.
Right, but the problem here is that he had raised this issue in the hearing and says this can't be raised here. And I think it's a particular hardship on the litigant in this situation when the judge meshes them both together as one order and says you have to pay this entire amount and imposes an order on Mr. Chapdelaine, who at that point had already, the judgment had been satisfied and he was out of the case. He wasn't appealing. It was over. So to say later that the appeal that you were bringing on the underlying judgment somehow must have been now changed and added in to add this complaint, I think is substantially unfair.
That doesn't answer, however unjust what happens, you still have to file proper notices of appeal to get review. When we've got one notice of appeal, and Bailey tells us you need two notices of appeal to raise both of those. And since the notice of appeal doesn't specify, I mean, maybe you have some theory on how it counts as two notices of appeal, or otherwise we can rule on it. But if not, I need to know which thing it appeals.
I suggest, Your Honor, it appeals both because of the way the order was written. The order, what the judge had to do in order to make a Section 44 order was to amend the judgment. She didn't. This order is not an amendment of the judgment. The judgment's already been done and satisfied. And what the judge didn't do was amend the judgment. So there's no valid order that he could even appeal legally. If you haven't amended the judgment, then how is he going to appeal from a
if there's no appealable judgment at all, then why are you here?
Well, because two reasons. One, there's an order in this judgment. There's an order that he pays this $37,000 in costs, and two, Mr. Constantino has paid it already because in order to avoid the accumulation of interest on it. So we're here to get that vacated because it's an illegal order.
If there's no judgment, you have to litigate in the Superior Court and get a judgment, and then we can review it.
All right, and then I think we need an order from the court to say that if that's what has to happen. But there was no order properly made at all in the Superior Court. So I think that may be what the decision has to be if that's the direction you're going. But my argument is because the judge meshed them all into one and combined a cost order under 6F with a cost order using the terms of this statute, that I can appeal it on the grounds that I've raised. And in terms of the timeliness of amending a complaint, it may be too late now. The Commonwealth, first of all, it was too late when they tried it because it's almost, I couldn't find a case in which a judgment has been rendered and satisfied, and then it's amended to add another count of damages. You have 6F, but that's a whole different statute, a whole different standard.
Mr. Traft, I do see on the docket sheet that a judgment entered on the 6F fees and the Section 44 fees and costs on February 9th of 2018. So it wasn't just the judge's findings and rulings and an order for judgment. There was an actual judgment entered.
It was a judgment entered, but it was a judgment in the combination. And I think a judgment couldn't enter under Section 44 without amending the underlying judgment. It's not a new rule or a new judgment. They have to amend the original judgment.
Okay, but you have to appeal that in order to raise that, right?
Yeah, right. Well, yeah, yes, and that's fine if that's what has to happen. But I don't see
since you
that
have
as
to have
judgment.
two notices of appeal, to appeal it both to a single justice and to a panel, and we have one notice of appeal. What's right? Do we have the panel 118E appeal, or are we reviewing Justice Hanlon's ruling on the 6F?
Well, you're reviewing both.
How can we review both with one notice of appeal under Bailey?
Well, I think the answer would be that the order or the judgment on 44, Section 44 should be vacated and remanded for a further hearing in the Superior Court, a further determination.
But we can't do that unless we have appeal in front of us.
Mr. Traft, maybe you can shed some light on this. You filed a single notice of appeal, which didn't say whether it was appealing the 6F order or the Section 44 award. It just said it was appealing that judgment of February, whatever it was.
Right, isn't that both?
Yeah, because it was a single judgment that combined both. I understand that. At what point was a decision made, in your understanding, and by who, to treat that notice of appeal as an appeal of the 6F order that would go to a single justice of our court, rather than as a Section 44 appeal that would go to a panel of this court?
That was,
Who
no,
made
excuse
that
me.
decision and how?
The clerk's office in assembling the record. They assembled the record and sent it to of this entire judgment, sent it to the single justice.
The clerk's office, meaning the Superior Court clerk, or
Superior Court clerk.
and where do we find that in the record that they that they denominated it a 6F appeal?
I don't, well, I don't know how they denominated it specifically. I don't remember looking at the docket on that. But in any event, what did happen is it went to the single justice, the whole thing, the whole package. So you have one judgment, one appeal, and the whole package goes to the single justice.
Yeah.
So it's unfair to blame Mr. Constantino for not realizing the intricacies, especially since it's never happened before. No judge has ever done this.
Well, assuming that we have jurisdiction over the Section 44 appeal, maybe you can proceed to your arguments on the merits, and because time is growing short.
Right. Yes, I don't want to. Yeah, I only have 5 more minutes on that. So I'll rest on my brief on the other issues. The only thing I want to say on the cost is the Commonwealth wants costs for a paralegal. Their investigator was a paralegal. That's not court. That's not legal costs. That's not costs under the judgment. And so I think there's plenty of argument in that in the briefs. Well, let me get to the 6F issue, because obviously that is clearly before you, and I've got a heavy burden here. But the fundamental issue here is that the claims filed by the parties, both of them, in the Superior Court could not be frivolous. The two probate judgments filed a summary. There were summary judgments filed by the Commonwealth seeking to say this is already decided, and both Superior Court judges, probate court judges, sorry, said no, they haven't been decided yet. Because there are facts that we have to determine, and it relates to what was the nature of this settlement agreement among the parties, and we can't figure that out without a finding of facts, and that. Since that was litigated in the Superior Court has to decide it. So that's where it went to the Superior Court. Now, Mr. Constantino pursued the argument. Now, this is an argument pursued by the Commonwealth against Mr. Chapdelaine. And that's what they raised in the probate court. They wanted to have him liable too. And Mr. Constantino, the bulk of his argument was that Mr. Chapdelaine was responsible as well. The Commonwealth agreed, and the judge agreed and awarded it. How is that possibly frivolous? If it's adopted, if it's argued by the Commonwealth and it's adopted by the judge, can't be frivolous.
Counsel,
Counsel,
there are 3 different complaints in the record, 2 of which don't have any claims against the Commonwealth at all. But there's one at 141 in volume 1 that does have a claim against the Commonwealth. And it's labeled by your client as plaintiff's proposed amended complaint, March 28th, 2017. I couldn't find any indication whether that was allowed or even that this was even filed. Could you enlighten me as to what this document is and whether it was ever actually filed in court or became an operative complaint?
I think I forget now where exactly it was, but I believe it was allowed to clarify the issues that he had been raising, and I think it's mentioned in there somewhere in the brief. I apologize for not immediately being aware of that.
Well,
but
it's true. Doesn't it have a count that specifically says that the Commonwealth shouldn't have to pay on the lien?
There is something that says that. So to the extent that or any of the other claims that Mr. Constantino made, someone could say that they were potentially deemed frivolous. But that you have to, in order to award a 6F award, there has to be the substantial amount of the complaints. The idea is if someone raises a half a dozen complaints and 5 out of the 6 are fine, but one maybe have been a little off the track.
But what if under 6F, you've got multiple defendants and against one of those defendants, only one claim is asserted, and that claim the judge finds is wholly frivolous and without basis and so forth. Does it matter to that party's request for 6F fees that the plaintiff may have asserted other non-frivolous claims against other parties? In other words, can we look at the complaint on a defendant by defendant basis?
Yes, that's
Say against
absolutely
the
right.
defendant, everything that was asserted was frivolous.
I think it really has to be, because it is fundamentally unfair. It's one thing to split the ultimate judgment here to 3 ways and say everybody could be jointly liable for everything. But under 6F, if a complainant for the most part is making proper complaints, but has made one that's off the rails, you could perhaps punish him for that, but it should be apportioned by the degree of time that the Commonwealth had to spend in defending against that bad complaint. It's not, it's unfair to say, because you made one bad complaint, but we had to spend 80% of our time litigating proper complaints, you are obligated for 100% of the time we had to spend.
But if the only complaint you have against the Commonwealth is frivolous, and that's the only complaint against the Commonwealth in the whole case, then why aren't they entitled to all their fees?
Because, well, they may be entitled to all their fees against if the other complaints weren't frivolous, then they would not. They'd only be entitled to money for some of their complaints. And
Did you have a non-frivolous claim against the Commonwealth? Where is it?
Excuse me?
Where's your non-frivolous claim against the Commonwealth?
No, well, against the Commonwealth had to participate in this litigation to litigate a number of non-frivolous complaints. And what they're seeking is all of the time they spent on all of the case assessed against everybody. And that's where it's beyond any usual 6F award. That's
all right. Your time has expired, though. I want to, if other members of the panel have additional questions, I want to let them be asked. No, very good. Thank you very much.
Thank you.
We'll hear next from Attorney O'Neill.
Good morning, Your Honor. May it please the court, Paul T. O'Neill for the Commonwealth of Massachusetts Mass Health. This appeal involves, the court has correctly identified that it involves the very narrow issue of whether the single justice's affirmation of the Superior Court's award of attorney's fees under Section 6F is an error of law or abuse of discretion.
Hold on. Why is that? Our case law says if there's something that can be appealed both to a panel and to a single justice, and it doesn't specify, it's the panel appeal, not the single justice appeal that's in front of us. So why is this an appeal from the single justice ruling?
No, the panel appeal was already heard by the appeals court and was decided in the case. And
could you explain to me, since the transcripts that support the 118E ruling were not prepared until months after the old panel appeal happened, how that old panel appeal could have ruled on or even have raised the 118E issues?
Because under Bailey and the case law, it makes it very clear that any award of a 231-6F award is stayed pending the resolution of the appeal in chief, because they are interrelated and dependent upon each other. And this appeal was pending. The appeal in chief was pending at the time this was issued. The record had not been assembled. The briefings had not been submitted, or argument had not taken place.
There was no assembly of the appeal of the February 2019 order until after the decision in 18P 587, nor could there be an assembly because there were no transcripts. So how could the 18P 587 appeal be an appeal of the 118E order?
Well, the case law says it's required to be included in that case, and it was addressed in our brief that was filed in the case in chief, despite Mr. Constantino's recent allegation. If you look at footnote 2 of the brief, which I'm not sure our brief is in the record of this case, but in the case in chief in footnote 2, we addressed the attorney fees award in footnote 2, and the court also addressed the applicability of 118E section 44 in its decision on the last page of its decision, saying that 118E 44 didn't contain any priority of payment among defendants, and that joint and several liability was permissible under it. So it was before the court. Mr. Constantino chose not to argue it or bring it before the court separately. As far as the
before you hang all your hat on that suggestion, could you explain to me what violation of 118E there was from failing to notify Mass Health of the transfer of the property? What section of 118E that's a violation of?
I'm sorry. So there were 2 violations of Chapter 118E that were identified by Judge Fahey in her fee decision. And I would note for the court that her fee decision, which also incorporates her decision in chief on the judgment, incorporates all of that. The first finding was that, I just want to make sure I'm quoting the right one, that they did not notify, that none of the parties notified Mass Health of the filing of probate and provided them with a copy of the death certificate under General Laws 118E section 32, which is a requirement. The second violation was that, I'm sorry.
Where is that?
That is the finding of fact number 5. Mr. Constantino did not send the required documents to Mass Health under 118E section 32.
You're referring to the decision on the merits that was incorporated?
No, I'm referring to, that is a finding of fact in the decision at, the decision on the fees, Your Honor. And that fees decision is at Record Appendix page 121.
Yeah, I'm not seeing in paragraph 5 any statutory cite at all.
That is the reference, Your Honor. It's just 118E section 32.
Okay, and what makes you think that was the basis of the 118E award? Because what the judge says is the court finds that this amount can be recovered against both Leonardo and Constantino, both of whom violated General Law Chapter 118E by purposefully failing to notify Mass Health of the transfer of the property.
Yes, that's the other violation, Your Honor. That
Give
they fail.
me the statute that violates. What section does that violate?
It would violate 118E section 44 regarding the recorded lien, Your Honor. That is required to be paid when there is a transfer of property. But the other violation is a clear violation, Your Honor. Justice Fahey made findings about Mr. Constantino acting as attorney for Mr. Leonardo at the time, paying the filing fee for the probate court.
Let's go back. Tell me where in 44 it says that if property gets transferred, you have to pay the lien. I don't see the word lien in section 44 at all.
No, 34. It doesn't say, no, it just says that we can record a lien and that the lien is valid, Your Honor.
Okay, well, in what way did he keep you from recording a lien?
He did not keep us from recording a lien. He did not.
He didn't violate 34.
Well, the judge found that he did, Your Honor, that he had an obligation to notify Mass Health of a transfer and the lien and to ensure that the lien was paid. But the primary violation.
She found that correctly or she found that incorrectly?
Well, I believe she found that correctly. She found that he as an attorney and fiduciary involved in a real estate transaction, had a duty to do that, and that none of them did that in the context of the resolution of the 2009 Superior Court case that they were involved in. And she made several subsidiary findings that all of the parties were aware of the lien and of the obligation to satisfy it. And in fact, not only did they not do that, they purposely chose to not notify the Commonwealth of that case so that it could protect its rights. And those findings are in her decisions on both of those issues.
And how do we find that's a violation of Chapter 118E?
Well, you may disagree and say that that's not a violation of Chapter 118E, but that doesn't get over the violation of 118E Section 32, which requires that a copy of the petition for probate and death certificate be provided to Mass Health. And she clearly held.
How do I discern that was a basis for the 118E award?
Correct.
How do I discern that? Because that's not what she says when she discusses 118E. It's just a factual finding.
Well, she does. She says that there were violations of Mass Health law. Right? The statute says if there is a violation of Mass Health law, then Section 118E44 applies in this case.
So if her damages are based on this violation that isn't a violation, and you say there's some other violation, doesn't it have to go back?
Well, her damages are based on the fact that they did not notify Mass Health as required under 118E Section 32. And she holds Constantino primarily responsible because he helped prepare the petition as attorney for Leonardo and also provided the filing fee. And also Mr. Chapdelaine was aware of that, although she doesn't specifically find him responsible.
So the party's attorney can be held liable under Section 44 for actions of the party?
Yes, and she did an analysis because the petition was not provided under 118E Section 32. It says that anyone who receives a distribution from the estate, a distribution of assets belonging to the estate, is liable to Mass Health for the payment of its claim. And so her analysis in both the judgment in chief, which is incorporated into her fee judgment, follows that line of reasoning that Mr. Chapdelaine only received approximately $46,000 from the estate in payment of fees. Mr. Constantino, however, received all the property worth over $1 million, so his liability was not capped at any amount. But
Mr. Constantino still has to have been found to have violated 118E 32 in order to be liable under 118E 44.
Correct, and she did find that.
Does receipt of proceeds or a distribution when your client didn't report the lien or didn't report the death, I'm sorry, make the attorney violative of 118E 32? I understand he may have received the distribution, but did he violate?
Under the circumstances of this case, the judge found that it did, because Mr. Constantino was acting as his attorney, filled out the application with him, provided the filing fee for the application. And in fact, I believe the judge in the ruling indicated that the reasoning why he didn't do everything was he was concerned about not having malpractice insurance. She found a clear violation of that. And that is the basis of the 118E award, which I agree with my brother is not before this court properly and has been waived.
So why doesn't the 118 violation have to be criminal?
It doesn't have to be criminal. The statute says that the Commonwealth can bring a civil action in lieu of or in addition to a criminal case. So there's no criminal case involved in this case.
How is this in lieu of or in addition to a criminal prosecution?
Well, there was a motion to add a 118E Section 44 claim at the end of the case. Originally, it was oral motion.
It's not in addition to a criminal prosecution. How is it in lieu of a criminal prosecution?
I'm not sure I quoted the statute exactly correctly,
It
but
does say either in lieu of or in addition to a criminal prosecution.
yeah, it can be either.
Okay,
You
but
can bring,
so prove to me it's one of them. It's not in addition to a criminal prosecution. So how is it in lieu of a criminal prosecution? What criminal prosecution could you have brought?
well, it was in lieu of a criminal prosecution. We could have brought a criminal prosecution for fraud, for not paying the mass health lien. And we chose not to bring that because of the higher standard, but that would be something that the Medicaid fraud division would bring, and they did not bring that.
You can bring a criminal prosecution for not paying a lien?
I can't bring that, but the Medicaid fraud division could bring a fraud complaint for, this was not, I think we need to back up. This case was not a case where a family member inherited property. This was, the underlying facts in this case were a third party came in and basically ended up with an elderly woman's property for $1, which he admitted on the stand he did not pay, and then proceeded to refuse to pay the lien that belonged to the Commonwealth and its taxpayers so that that money could be returned to the general fund of the Commonwealth. So yes, I believe that a criminal prosecution could have occurred in this case based on the facts of this case. Judge Fahey also found that Mr. Constantino, in writing, made misrepresentations to the Social Security Administration, which is also in the record in writing. That did not occur in this case, but this wasn't a family member inheriting property. It was a third party. If you look in our brief also, it's very similar to the Executive Office of Health and Human Services versus Cooperstein case, which was decided by this court at 97 Mass Appellate Court 1125. Same scenario, third party came in, duped the estate, the heir, took the property, was aware of the lien, knew it needed to be paid, and did everything they could to avoid it and forced the Commonwealth into literally decades of litigation. This case began in 2009 and even a little bit earlier. So this has been 12 years of litigation in several forums, probate court, this court, single justice appeals court, back to this court, Your Honor.
What's the claim against the Commonwealth that Constantino raised?
You correctly identified it in the complaint. It was a declaratory judgment action asking that our lien be declared invalid, that it automatically expired upon death, and that no one had to pay it. I would just point.
Show me where this thing at 141 in volume 1 of the appendix was filed or admitted, because your answer doesn't connect to it. You have no answer to this count. And certainly when she describes in her original judgment what she's doing, it doesn't seem to connect to this complaint. And I don't see it on the docket.
So I think it was submitted by Mr. Constantino. And I do believe, Your Honor, and I will check, and if I can, I will confirm, the case was very convoluted. Mr. Constantino submitted many things. I believe that Mr. Constantino, after the first day of trial or during the first day of trial, dismissed this complaint. I will have to check for you. But even though he did that, he had filed motions eliminate, asking for the exact same relief for the lien to be invalidated based on the fact that it automatically expired at death. If you look at 42 USC 1396 PA3, Congress has specified that the only time that a mass health lien is automatically extinguished is when a mass health member is discharged from the institution and returns home. And that it means to their home, not to a hotel or somewhere else. And it's intended to lift the lien so that they can access equity if they're going home to be taken care of. So.
Okay, your time has expired, though. If there are further questions for you, I want to.
I'm afraid I got at least one more.
Okay, go ahead.
which is the judge on the 231 E. Let me get it so I get it right. She found the parties' claims and course of conduct, which required Mass Health to continue to litigate its entitlements in the lien, was wholly insubstantial, frivolous, and not advanced in whole faith. It makes it sound like she based this not just on the claims and the litigation, but on the many terrible things that were done before the litigation started or in the earlier litigation. Do you disagree with that?
I don't think that's totally true. I think that she was referring to the fact that Mr. Constantino continued to raise this issue repeatedly at trial. He raised it with a motion to eliminate, and then he raised it with an emergency motion to amend his complaint, and then orally continued to argue it. And this is evidenced even by the fact that in the case in chief, he did not argue this issue of the automatic expiration of the lien, but then when he filed his FAR request, he included the whole same argument that had been decided by two probate court justices. I mean, the foundation of the case is that the law of the case had been established by Judge Ward and Judge Christopher in their decisions, saying that we reviewed the law and the lien remains valid as to Mr. Constantino's interest and must be paid. And he continued to challenge that throughout. He could have simply left out the Commonwealth and litigated among Mr. Leonardo and Mr. Chapdelaine as to who was responsible for payment without challenging the validity of the lien. But he continued to do that, forcing the Commonwealth to appear and make sure that that interest was defended on behalf of the taxpayers.
You agree that those latter claims against the other private defendants were not frivolous or wholly insubstantial? It's only the claim against the Commonwealth?
I agree.
Yeah,
I agree. I think there was a legitimate, the probate court did send the case legitimately to determine who bared responsibility and how much responsibility, yes.
Yeah.
But that did not need to necessarily involve the Commonwealth.
Okay, your time has expired. If there are no further questions, Attorney Ryan, who represents Mr. Leonardo and Chapdelaine, is also available here if there are questions from members of the panel.
I have a few. It's correct that neither of your clients filed a notice of appeal?
That is correct, Your Honor.
So if we reverse the judgment against Constantino, doesn't that mean that your clients are responsible for all of it?
Well, I don't necessarily agree with that based upon the conduct that was in the underlying judgment. Because it was joint and severally liable, and it seems that the conduct was between all the parties as the trial judge found. I believe striking one necessitates striking it all for everyone.
How can we strike the judgment against your clients if they haven't filed a notice of appeal?
Well, I believe it joins in with what the arguments that were put forward by Attorney Costantino on this matter, that it should have never been awarded in the first place to him, which is jointly the same position that my clients would have.
I get why it would work logically, but how do we have the authority to reduce the judgment against your clients without a notice of appeal?
That Your Honor, that I don't necessarily have a answer to, other than it only makes sense if it goes one way in a joint where somebody's found jointly responsible. It must go for all.
Okay, thank you.
Seeing no further questions, thank you very much. Very helpful argument to us. The case is submitted.
Thank you, Your Honor.
Thank you, Your Honor.
I will go ahead and admit counsel for the next case.
Eric,
don't
do
mind
we still
Yeah,
need Patricia in?
I think you have to stop and restart the recording, but not the streaming. Is that right? All right.
Correct. Yes, thank you very much.
Oh, okay.
Yeah, I did just stop recording.
Thank you.
And I'll admit counsel now.
One of you has your YouTube streaming on. If you could turn that off so that we don't get feedback, that would be helpful. Due to oh, I've only got two of you. We are still waiting for, there we are, Attorney Sheehan. Due to a technical problem that we've had, we are currently streaming live, even though we haven't started the case yet. So I would just alert you all that we do stream live, and so the public can see argument, and a copy of this, an archived copy, is also put up on YouTube for the public to watch later. When the clerk's office alerts us that we are, can you all hear me, Attorney Salvis and Sullivan?
Yes.
Ian?
Yes, Your Honor.
Yes, Your Honor.
Excellent. All right, so the clerk's office will let us know when we are recording, and I will call the case.
We are recording.
Thank you very much. Welcome to the Appeals Court. I'm Justice Rubin, and I'm joined today by Justices Sachs and Ditkoff. The next case we'll hear is number 20-290, SLIVE and HANNA Inc. versus Massachusetts Commission Against Discrimination and another. The rules for argument are the same here as they are in our court when we are in person. We are, of course, having a teleconference argument due to the ongoing pandemic. That is 15 minutes per side with no rebuttal. Our understanding is that the appellees are, the appellees are dividing their time with MCAD getting 10 minutes and then Mr. Murphy's counsel getting 5 minutes.
Yes, Your Honor.
We will begin with Attorney Salveson whenever you're ready.
Thank you, Your Honor. May it please the court. There are two issues on appeal in this case. The first issue concerns and arises out of the events between the filing of the Cambridge District Court action up until the time that the Norfolk County Sheriff liened the Mr. Shanahan's minivan. And that issue is whether the boundary of the constitutional right to petition for redress of a grievance stops at the entry of judgment, or whether it includes the post-judgment proceedings that are necessary to enforce the court's judgment. The second issue concerns the events thereafter, and that is whether the settlement discussions between Mr. Slive and Mr. Shanahan's ex-wife constitute adverse actions that are necessary to state a Chapter 151B retaliation claim. My preference, rather than going through and restating the arguments in the briefs, is to address any questions that the panel may have, because I think that's the best use of my time. Although I'm happy to go through and start the arguments.
Well, I'll start with a question then. On your argument that the execution process, the levy on the execution is subject essentially to the same constitutional protections as litigation. Is there any limiting principle to that? And let me try to elucidate that with the following hypothetical. Can a party choose to levy on property, the taking of which will inflict the maximum pain and disruption on the judgment debtor for the avowed purpose of inflicting emotional distress in addition to collecting the amount of the judgment?
I think the limiting principle, which exists in some cases that I've read over the course of now many years, is that if the execution is performed in the usual and customary manner, and I think what you're describing potentially goes beyond the usual and customary manner, and is something that the court would consider improper, then that is an improper use, a misuse of the constitutional protection.
Well, I'm not sure how it is outside of the usual manner. Let's say the judgment creditor is aware that the debtor has two pieces of property, and taking one of them and selling it at a sheriff's sale will not cause any particular disruption to the debtor other than the loss of the property. But taking the other will produce significant disruption in the debtor's family and personal and employment life and so forth. And the creditor says, I'm choosing the latter one because I want to not only get my money, but inflict distress on you and disruption on you.
I think that would be a misuse of the right. And I recall a case where the debtor, where the creditor instructed the sheriff to go in and take personal belongings of the debtor. I think they were family photographs, something of that nature, which is the personal property of the debtor, and it was, it was subject to execution. And the sheriff went in and took those things, and a court found that that was a misuse of the statutory right.
So what is the test for determining misuse?
Well, it doesn't exist wouldn't exist in this case because there was no choice that the creditor had. I'm happy to talk about it, but keep in mind.
I mean, we know at least that the creditor was aware of the van and the house, and evidently chose to take both, or to put a lien on the house as well as to seize the van.
Right.
So conceivably the creditor could have said, I'm going to leave the van alone, even if the creditor didn't know, even if S&H didn't know in advance that of the wife's use of the minivan and so forth. Conceivably, the S&H could have said to the sheriff, just put the lien on the house and we'll sell the house if we have to.
Right. And as the court would probably well aware, in 2008, the value of real estate in 2008 was not necessarily over and above any mortgage on the property. And there's no evidence that there was any equity in the house. As a matter of fact, there's no evidence that there was any equity in the car, in the minivan.
Okay. But let's get back to the question of what is the test for determining whether a levy, a creditor's directive to the sheriff to levy on a particular piece of property is not constitutionally protected.
Now, I don't know that I could provide a clear-cut rule for the court to use. There may be, if there's some emotional attachment that is reasonable to assume that the debtor has to the property, that taking that particular piece of property is unusual and out of what the ordinary and usual course of the sheriff's execution procedure would be. Cars are taken all the time, motor vehicles are taken all the time on execution. And so I don't think there would be a rule that would say, well, I have a really, well, there might be. I mean, you might have an attachment to, and if the creditor knew that you had an attachment to the car that your father made for you, or, and you take that as opposed to.
Well, the reason I'm pressing you for a test is because I want to then ask you, why does this case fall on the permitted side of the test? And here, even if the S&H didn't know at the time how the minivan was being used, once the ex-wife called up and said, hey, I need this to get my daughters around, S&H understood that this was causing some disruption in the family. And at least according to what the hearing officer found, and I understand your client testified to the contrary, S&H did not immediately say, okay, we'll not levy on that property.
Right. And the levy on the car is within the usual and ordinary course of what the sheriff does to enforce an execution. And there's no evidence that there's some emotional attachment that S&H was aware of. And quite frankly, I think calling up and saying, I really need this car doesn't take it out of the ordinary course of what debtors are going to say anytime any of their cars are taken. There's a presumption, I imagine, that debtors, they have cars and they need the cars for transportation. And this is unlike, a car that your father made for you or something like that. This is a minivan and it's the only car there. That the only choice was, can SLIVE and HANNA only take the car and then not put a lien on the house? Or can they only put a lien on the house and then not take the car? Or having, the debtor call up and say, hey, I have this problem under Massachusetts law where they required to release the car. And there's no case that I'm aware of, no statute that would force them to give up their judicial lien. They're entitled to be paid on the judgment, and that's an appropriate way to have them paid.
Section 34 of Chapter 235 lists 18 categories of property that can't be levied on. Is that statute constitutional?
I assume it is, yes.
So if it's constitutional to say you can't levy on certain properties, why isn't it constitutional to say you can't levy in a way that is retaliatory to someone's MCAD rights?
I think you probably can't levy in a way that is retaliatory, that is improper. And what the sheriff did in this case was what the usual and customary manner of taking the car. There's nothing improper.
We have a statute that says that you can't retaliate against someone for complaining about discrimination. And if we are allowed by statute to say you can't levy in certain ways and of certain property, why can't we say as a statute you can't levy in a way that's intended to deter people from vindicating their rights against discrimination?
You're saying if there was a statute that said that, or you're saying the MCAD on their own?
I mean, there is a statute that says you can't retaliate against people.
Right, and you can't retaliate against people. They have to suffer an adverse action. And what you have here is you have the two rights in conflict. You have the right to redress. You have the right to satisfy judgment. And the statute gives you the right to levy on the car. And you have the statutory rights under 151B. And the question is, when you have a conflict, what do you do? And I think the Constitution sort of trumps the statute.
So the one of the things that's exempt from, your client thought this was his car when you had it levied. Is that right? Is that my understanding?
I'm sorry. No, the client.
He didn't think it was his car, thought it was the wife's car?
No, my client is SLIVE and HANNA, is the creditor, and he
tells the sheriff to levy on this car. Did he think it was Howard's car or Howard's wife's car?
Rick Shanahan's car. Yeah, the sheriff is the one who actually told us that at the registry there was this car registered that he owned to Richard Shanahan, and so we believed it was Shanahan's car, and it was.
So if you thought it was Shanahan's car, why wasn't it exempt as an automobile necessary for the debtor's personal transportation or secure and maintain employment under 235 section 34?
Because he had two cars. He had this car and a truck.
And the levy statute says that once you seize something, within 14 days, you have to auction it. But instead, your client held the car for a month, got it to incur $2,000 apparently of storage fees, never had it sold, and never had it used to satisfy the debt, which was still owed at the end. So how is that a proper execution under the statutes?
Well, that wouldn't be a proper execution statute because that's not what happened. What happened was the sheriff levied on the car, and the next day, the ex-wife, Shanahan's ex-wife, called to ask for the car back. The following day, they had the second conversation, and my client, Mr. SLIVE, testified he agreed at that time. Obviously, at some time he agreed, and what happened is Shanahan's ex-wife had to get up the money to pay for the storage costs and the sheriff's fees, which SLIVE and HANNA was not going to pay for, and it took her some period of time to do that. So any delay was caused and the result of her trying to get those costs together.
So even if you had a constitutional right to seize the car and sell it to pay the debt, why did you have a constitutional right to seize the car and not use it to satisfy the debt?
We were allowing her, pursuant to our agreement, to take the steps that she needed to take to get the car back. It would have been cruel almost to agree that you can have the car back and then to tell her, and if you don't do anything in 14 days, it's going to be sold. Too bad. And we weren't the cause of any delay. We were happy to release the judicial lien, but the wait was because she had to raise the money to pay off the costs associated with the.
Since the wife testified that's not true, that your client said, no way will we release this lien unless he drops the MCAD complaint, isn't that dependent on that fact finding, that the wife's testimony be discredited by the MCAD hearing examiner?
Except for the fact that we obviously dropped the lien, because otherwise she wouldn't have gotten the car back. So if Your Honor is under the impression that we refused to give her the car back, that flies in the face of the fact that she got the car back. So I'm not really sure what to tell you. I mean, the undisputed fact is she got the car back, and it took her, I think, 3 weeks, or there was a period of time of 3 weeks between when the sheriff took the car and when she got the car back. And I've explained that that delay is because she was raising the money that she didn't have. So unless there are further questions.
Your time has expired. Is there another? Yes,
I do have one question. You alluded at the beginning to there being 2 issues, the second one being that there was no adverse action. I saw that you raised that issue before, and you've characterized it in your brief as a non-constitutional argument. I saw where you raised that before the commission, but I didn't see it raised in your motion for judgment on the pleadings or in the motion to reconsider. So I'm wondering if it's preserved for us to consider.
Yes, it wasn't really addressed before the commission because the way that the hearing officer and the commission looked at it was one entire proceeding. And it was not until we got to the Superior Court where Judge Squires-Lee divided the proceeding.
Yes, I understand that. What I'm getting at is the no adverse action argument, which you've characterized as a non-constitutional argument. Not that this was constitutionally protected petitioning activity and so can't possibly be retaliation, but that the levy on the minivan was not, legally speaking, adverse action.
No, I'm sorry. The levy, what clearly is the adverse action. The argument was that the settlement discussions were not the adverse action, that the taking of the car was the only thing that caused any harm to anyone. And it wasn't until the Superior Court hearing that Judge Squires-Lee said, well, I understand the taking of the car was an adverse action, but also the settlement discussions themselves were somehow an adverse action. And so that second issue didn't exist until after the hearing before the Superior Court, which is why I had to file a motion for reconsideration.
Okay, thank you.
Okay, thank you very much. We will hear now from Attorney Sheehan.
Good morning, Your Honors. May it please the court, the fundamental issue before the court today is whether MCAD correctly concluded that an employer seizing property belonging to an employee during the course of the execution of a court judgment with the explicitly stated aim of pressuring that employee to drop his MCAD claim is unlawful retaliation under Chapter 151B. SLIVE and HANNA claim that retaliation of 151B is absolutely constitutionally immune simply because the retaliatory act is connected to an underlying lawsuit. It is not. The broader issue of whether an employee's mere filing of an otherwise valid lawsuit to recover a debt from an employee, from a former employee, can without more constitutionally form the basis of a Chapter 151B violation is not before the court at this time. Rather, the issue is that when an employer commits an act which is plainly intended to threaten or intimidate an employee into dropping a discrimination claim, the employer is unlawfully retaliated against that employee for exercising his rights under Chapter 151B, even when that act is related to a valid lawsuit. Any constitutional protected afforded by the right to petition the courts is limited by the law's prohibition against unlawful retaliation. And that is what
so you're saying the constitutional right to petition the court for redress of grievances or to petition the sheriff to go out and execute on the court's judgment is limited by the statutory prohibition on retaliation?
We're looking at it two different ways. With regard to the underlying right to bring a valid lawsuit against a former employee, the commission's not contesting that under these circumstances.
It's the execution.
Correct. Yes,
right.
sir.
But how does the petition for redress of grievances stop at the courthouse door when you're going out the courthouse door? And you can get a judgment from the court, and that's the effort to get the judgment is constitutionally protected. But if you try to execute on that judgment to get actual relief, to get the money paid that the court says you're owed, that's not constitutionally protected.
I'm not sure that the court needs to reach that issue in this case, but if the court, just because the facts are so egregious, but if the court were to reach that issue, what I would argue is that the actual execution of the agreement, having the sheriff go out and take the property and selling off that property, that's essentially a ministerial act, an administrative act that's largely governed by.
Why does that make a difference to whether it's constitutionally protected, whether it's discretionary or ministerial? I understand that it might have something to do with the degree of immunity afforded the sheriff, but why does it matter to whether it's an exercise of a constitutional right to petition for redress of a grievance?
I think the case law bears out that if you have a valid underlying court case, which is not being contested by the commission in this case, that you have a right to go to the courts and to ask the courts for redress. The judge says, okay, you win the lawsuit. In this case, it was a default judgment. And then the statute provides the method by which that actual act itself is carrying out. And that's where the retaliation occurred, in the carrying out of the execution, not just seizing the van, but when SLIVE explicitly said twice to Mrs. Shanahan, you can have the van back if Mr. Shanahan drops his lawsuit.
Yeah. So is it your contention that the entire execution process, the levy and execution process, is not constitutionally protected, or that the facts of this particular case put it beyond the pale of whatever protection exists?
I would argue that in this case, it's absolutely a bridge too far. Whether or not that's the case.
And what's the test for determining too far?
I think it comes down to motive, Your Honor. And that's the essence of any retaliation claim. If there'd just been a seizure, a routine seizure of property, SLIVE and HANNA goes and asks the sheriff, hey, go take some property and sell it up and satisfy the judgment. Without more, I don't know that there would be evidence of retaliation. But in this case, That's where the particular facts come in, and that's the essence of any retaliation claim. Whether or not the person who's committing a particular act is tying it to and is using it as a cudgel for essentially getting a plaintiff to drop an
But
MC claim.
so you're saying it would have been permissible to levy on the house?
Possibly.
Well, if you're saying it's not permissible to levy on the house or the car, then you're saying that he can go ahead and get a judgment and maybe even have an execution issued. But if he tries to do anything with it, meaning SLIVE and HANNA, that's retaliation. So I guess I need to know, was it permissible to levy on the house?
If it was for a non-retaliatory motive, sure.
All right. So then if the, I mean, putting aside whether the house was underwater, couldn't the same arguments about levying on the house be made as were made about levying on the car? This is totally disruptive to my life. You're trying to take a house that, at least on paper, is worth several $100,000 to collect an $8,000 debt. You're not just trying to collect the debt, you're trying to pressure me to drop my MCAD claim.
Correct, Your Honor. I think that what property that Mr. Shanahan owned that that SLIVE and HANNA was seeking to possess is almost immaterial. The question is that when they made that choice, when they conveyed that intent to seize that property to Mrs. Shanahan, and she tells them, I need that van to transport my kids, just like anyone, as you and Justice Ditkoff had previously pointed out, anyone could say that with regard to any piece of property that they owned. But in this case, that's where SLIVE steps in and retaliates when they say, you can have it back as long as your husband drops the MCD.
If it's retaliatory to take the van, and the same arguments could be made if SLIVE and HANNA had focused solely on the house, then that means that SLIVE and HANNA can get its judgment, can get its execution, but can't levy on it without facing a retaliation penalty from the commission.
Only if the evidence shows that there's retaliation. In this case, the evidence of retaliation was clear. If there hadn't been clear evidence of retaliation, I think the determination of the commission may have been different. If the sheriff had just gone and said, okay, I'm taking this property, and Mrs. Shanahan called up and said, hey, this is super inconvenient, and SLIVE and HANNA just said, tough luck, we're entitled to execute on a judgment, then I think that would have been one set of facts that might have led the commission to a different conclusion. But here it's Mr. SLIVE himself who lists the quid pro quo.
The problem here is that the commission believes that the whole lawsuit is retaliation. That the only reason why they even filed a lawsuit was because this person was complaining of discrimination, and there's plenty to support that. But the lawsuit is constitutionally protected. But if the whole lawsuit is retaliatory, then anything you do after the lawsuit has got to be retaliatory, because it's all based on a retaliatory motive. So once the lawsuit's retaliatory, how could they do anything once they have the judgment without being retaliatory?
I think there's two different issues, Your Honor, within that question. And the first is that, yes, I do think that the motive for bringing the lawsuit was retaliatory, and I do think that the evidence in the record bears that out in the fact that SLIVE and HANNA had a history of making loans to other employees and then not collecting on them, or using them as write-offs for, tax purposes.
Was there any evidence, by the way, of what the amounts of those loans were?
I believe there was not an express finding in the record, Your Honor, but I believe based on the district court judgment that the amount owed was somewhere in the realm of $8,000.
No. I'm talking about the other judgments or the other loans that SLIVE and HANNA made but didn't collect upon.
I'm not aware of any, and that's a record of the hearing officer.
So we don't know if the amount is a valid reason for explaining why SLIVE and HANNA might have sought to collect on this loan, but let some other ones to other employees go and write them off as losses.
Correct, Your Honor. I would defer to my sister counsel on that, who may have more background on their history of loans.
My question again is, if you have a retaliatory lawsuit, then how could anything executing that judgment of that retaliatory lawsuit not be retaliatory?
Because there has to be evidence that the execution itself is motivated by retaliation, just like in any other retaliation claim. In this case, there was. In other cases, there might not be. And I see my time is almost up. If the court has any further questions, I'm happy to address them. If not, I will defer to my sister counsel.
Seeing none, thank you very much. We will hear now from Attorney Sullivan.
Thank you. May it please the court. I will try to address some of the issues that have already been raised rather than presented just general argument. Your Honor's question, we're asking about the amount of what it was, and there is evidence in the record regarding that, and I can tell you where it is. I don't recall off the top of my head how much the amount was, but I believe that anything to do with the testimony and the documents pertaining to the fact that SNH did not ever try to collect these loans against other employees, except for one instance where there was a criminal complaint for an employee who stole funds from the employer. Anything to do with the fact that they did not move to enforce those, they did not sue people, they wrote them off as tax deductions. I'll give you some record sites in case they're helpful to you. It's so Record Appendix 1 at 27, 34, 850, 851, 857, 864, 865, 868, 1014, 1080, and then Record Appendix 3.
Okay. All right. If those show the amounts, then that will be helpful. I don't think we need a full catalog of them.
Okay.
If you think it's necessary, why don't you write the sites in to us through a letter?
Okay.
But let's use it this time as productively as we can.
Can I just ask, are these sites of the debt that Shanahan owed? Because I looked at one of them and it was.
No, there were a few more in the third Record Appendix. There's very few, 165, 175, 178, and 195 to 198. I believe there's documentation in the record of some of these other debts that these other folks owed. And it may state what some of the amounts are, but I do want to note for the record that that concern was never raised at all throughout this case, that the amount was, that was why they, allegedly, that was not a motive that was ever asserted, the amount of the debt.
So let's go back to the central question. Why isn't asking a sheriff to levy on an execution within the constitutional right to petition for redress of grievances?
Well, for a couple of reasons, Your Honor. First, as Justice Ditkoff noted, our position is that the bringing of the suit in and of itself is retaliatory, and that the MCD in the first instance at the hearing officer and the commission.
Let's focus on the execution for now. Okay.
Well, because the process is entirely driven by private parties. The courts play no role whatsoever in that. There are many choices.
Well, but the deputy sheriff is not a private party. The judgment creditor comes to the deputy sheriff, says, I have a grievance. I've got a judgment. It hasn't been satisfied. I've got the court to issue an execution. Now here, I'm giving this execution to you. Would you please, pursuant to the statutorily prescribed procedures, go find some property that is owned by the judgment debtor and levy on it? How is that a private process? Why isn't that a process of asking the executive branch of government to redress your grievance?
Well, because that assumes that they had to, in fact, execute on the judgment at that time.
Well, but the levy, the execution wasn't issued, if I'm correct, until about 13 months after the default judgment.
That's because they asked for it at that time. They could have chosen not to ask for one, knowing that.
Yes, or they could have chosen to ask for one the moment they got it, which I suppose would have, increased the inference that the MCAD drew of retaliatory motive. But be that as it may, whenever they chose to ask for the execution, it wasn't a private process. It's not self-help. You go to the sheriff, and this process is designed to avoid conflicts between private parties that may lead to violence over satisfying debts. It's the deputy sheriff who goes and takes the property and sells it, not the creditor. So why isn't that why isn't that a governmental process for redress of grievances?
Because it's a ministerial action, and yes, of course, we have to have some orderly system of resolving disputes. Otherwise, there would be mass chaos and pandemonium. But that doesn't necessarily mean that everything that is done that is an extension or that is done by the government or an officer or someone who works for the government is a constitutional act. Sheriffs can be sued in tort if they
execute on property that doesn't belong to the judgment debtor. That's the Katie case. But I think that case recognized Supreme Court cases saying that where the sheriff is executing on property that's properly subject to execution, that the sheriff is immune. So is your position that the process of execution and levy is not constitutionally protected?
Yes.
Can a sheriff refuse to levy even if it's within the statute? Or does he?
Yes, I believe so. I see my time has expired, so unless there are other
has expired, so unless there are further questions, I see none. Thank you all very much. Excellent arguments. The case is submitted.
Thank you, Your Honors.
Thank you.
And we have stopped recording and we have counsel for the next case. When you're ready, I can admit them.
Let's let them in. We'll take a break after this case. Good morning, counsel. Due to a technical issue, we are now streaming live, even though the argument has not yet begun and we're not recording, just to give you a heads up. Your cameras and microphones will be on throughout the proceeding. And once recording begins, and I should say we stream live, and an archived copy of this argument will be posted on our YouTube channel so the public can see it either live or at a later time. Once we begin recording, I will call the case and let you know what the rules for argument are. I take it you both can hear us?
Yes, Your Honor.
Very good.
Excellent, then I'll start us. We are recording.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined by Justices Sachs and Ditkoff this morning. We are holding argument by teleconference due to the ongoing pandemic. The next case that we will hear is number 20-805, DIV Sumner Street LLC versus Great American E&S Insurance Company. The rules for argument are the same here as they are when we hear argument live in the courtroom, which is to say 15 minutes per side, and there is no rebuttal. And we will hear first from Attorney Pickering Cook.
Good morning. May it please the court, Nina Pickering Cook, representing the appellant DIV Sumner Street LLC. In 2015, my client DIV bought property in East Boston, and when it did, it also purchased a particular type of insurance policy, an environmental pollution policy, to protect itself against the possibility of pollution when it developed that site. When pollution was discovered, DIV spent millions cleaning it up. But when it made a claim for those costs under that particular policy, their insurance company, Great American, denied coverage on the basis of an exclusion. Now, the meaning of that exclusion is at the heart of this case. I'll explain how DIV's reading not only makes more sense, but is in fact required by Massachusetts law. That point is illustrated well by the fact that one of the cases that Great American relied on in the Superior Court, the Performance Transport Inc. case, has since been overturned. But before I get there and talk about the merits of the coverage dispute, we should discuss the fact that this case reaches the appeals court with a fatal procedural defect. As we have briefed for your honors, no final judgment has entered in this case. It is clear there is no separate document or docket entry as required by Rule 58A. A concluding sentence of the decision like the one we have here is simply not good enough according to the SJC in the Mason M case. Now, this rule has not changed over time, as Great American is arguing. In fact, in only 2007, I believe, this very court in the Zielinski case versus the Connecticut Valley Sanitary Waste Disposal stated, and I'm quoting, Massachusetts courts generally continue to require strict compliance with Rule 58A's separate documentation rule, close quote. Now,
Also, the Swampscott Education Association case says that we may not require strict compliance where no other party has been prejudiced. I understand your argument is that you have been prejudiced, but the standard in Swampscott is whether another party has been prejudiced.
Well, I think the standard in Swampscott is that there may be prejudice. So there are occasions, as Great American has pointed out in their cases.
Well, Swampscott says, and I'm quoting, where no other party has been prejudiced by that fact. It doesn't say prejudice to the appellant, him or herself, from filing a notice of appeal before there's a judgment on a separate document is grounds for determining that we lack jurisdiction. I mean, the appellant clearly wasn't confused about when the appeal was read.
Two responses to that, Your Honor. The first is there is no prejudice in this case to any other party. The Great American is not prejudiced at all if we remand back to the Superior Court. This case barely got out of the gates. There was no discovery. This was done motion on judgment for the motion for judgment on the pleadings. So this is a case that it's not as if we spent years in litigation here. And so there's no, if this were remanded as a result of this technicality, there is no prejudice to any other party, as you state in the Swampscott case. As you say, there would in fact be significant prejudice to my clients. DIV is seeking to have the rule apply in order not to lose its rights to a full review on the merits, which is essentially the opposite of the cases that Great American is citing, where courts stray from the rule. They typically stray from the rule in order to prevent a loss of rights.
Well, I think one reason you're going back is because you want to go back is because you have some arguments that weren't presented to the judge. One of those focuses on the phrase thereafter removed. As I look at the record, I didn't see where that argument was the focus of the briefing on the motion for judgment on the pleadings at all. So if we do have jurisdiction of the case, has that argument been waived?
No, Your Honor, that argument has not been waived. There's no new legal claim or new legal theory here. The case below squarely centered on the application of endorsement number 9.
Sure, but we don't define, there's no new claim here, but the Superior Court judge was not given an opportunity to pass on the theory that you're arguing now, that this phrase thereafter removed limits the exclusion to costs incurred after removal. So isn't one of the purposes of the waiver doctrine to make sure that and incentivize arguments being fully presented to the trial court judge so that he or she can consider them and reach an appropriate resolution before a decision is made about whether to appeal?
Two responses to that, Your Honor. As I said, endorsement 9 was the focus of the arguments down below and whether or not it barred recovery. The particular articulation of that argument may in fact be different, and that is not unusual at the appellate court at all. But the argument in the legal theory that endorsement 9 in fact bars or does not bar the recovery of for my client was wholly in front of the court before. The other response is that Your Honor, in the appeals court have de novo review here. This court can consider any arguments it deems relevant with respect to the interpretation of the interpretation of endorsement 9. Now, going back to the procedural issues, just briefly, Great American has accused DIV of trying to litigate a case that it's lost and getting 2 bites at the proverbial apple. That's not what we're doing here. The coverage denials under the other coverages, A and H, have never been litigated. There was kind of no full bite at that apple. And if Great American gets its way, there never will be. They have made it plain that they plan to oppose, and they believe we're procedurally barred from ever bringing those claims.
That's not before us, though.
I'm sorry?
We don't have to decide whether you would or wouldn't be barred from filing a claim against them. That's got nothing to do with this case.
That's entirely right, Your Honor. The point here is that if this case is remanded, then we can litigate all of the coverages in one case and avoid expensive and time-consuming litigation down the road about claim splitting. So there's no doubt that we're in this circumstance partly by my client's own making, but there is prejudice nonetheless, and that prejudice to straying from the requirements of Rule 58 in this case vastly outweigh any prejudice to Great American. Now, moving on to the substantive issues, if this court does not remand, then this case turns on the meaning of only one provision within endorsement 9, the site development exclusion. That exclusion can be found at Record Appendix Volume 1, page 52. I think it would be helpful to have that in front of everyone. Importantly, endorsement 9 modifies coverage B, and coverage B is entitled on-site and off-site cleanup costs. Now that is very important. The site development exclusion bars coverage for costs due to, and I'll quote the language, contaminated soil that is excavated or otherwise disturbed and thereafter removed from the covered location, unquote. In light of the fact that this provision is modifying coverage for on-site or off-site cleanup costs, the exclusion is best understood as barring coverage for any cleanup costs required after the contaminated soil has been removed from the site, i.e. off-site costs. An example of this would be at the site, a truck is filled with contaminated soil. It leaves the site, it overturns on a highway. That contaminated soil spreads to a stream.
Okay, that's a bit of a nonsensical reading. So let me ask you this. Let's say that, and I don't know what the rules are about various contaminated soils. Let's say that the law requires not merely that it be removed from your property, but that nothing be done with it until the contaminant is neutralized. And let's say that the neutralization of some contaminant must or ordinarily would take place off-site. So we dig up the soil with oil or whatever is in it, but we can't just dump it someplace. We have to treat it. And we treat it off-site. Your position is that that treatment is not covered.
That hypothetical gets tricky, Your Honor, because treatment of soil is otherwise dealt with in this insurance policy.
No, it would be a cost arising from contaminated soil that has been removed. So I need to understand what your position is with respect to whether that off-site treatment is or is not covered. I don't see, it doesn't say anything about spilling or additional costs. It says costs arising from the contaminated soil that is removed. So what's the answer to that?
If it is costs arising due to the removal from the site, after
not due to the removal, they are arising from the contaminated soil that has been excavated and thereafter removed, just like the words say.
Yes, so I believe that this exclusion bars recovery for off-site cleanup costs.
Okay.
Period.
But,
Your Honor.
Go ahead, I'm sorry.
Sorry, Your Honor made the point that you thought our reading of that exclusion is nonsensical. Hopefully
a reading that limits it to a subsequent accident, like spilling it on the road. It doesn't say anything like that. It does say.
That was just an example.
Okay, but it's an example you keep using presumably, but the realistic example I would think would be treatment of such contaminated soil offsite, and you agree that this bars a claim for that. So, for example, in that case, I gather your position would be the excavation costs would be covered, but when the soil is removed, now anything else that has to be done with it, not covered. Is that correct?
Cleanup costs that are necessitated after removal would not be covered by this exclusion. Now, Great American reads this provision to bar all costs arising from excavation and removal of contaminated soil. We believe that reading is completely inconsistent with basic tenets of Massachusetts insurance law. So first of all, we're dealing with an exclusion. Massachusetts law requires the narrowest possible reading of an exclusion. And that exclusion must be construed strictly in favor of the insurer and in favor of the insured, and in favor of coverage. Now, the Superior Court did not do that here. The reading imposed and put forth by Great American is the broadest possible reading of this provision. Courts such as the First Circuit in the performance transport case, in the SJC and the Gill case, find that the context in which that exclusion was issued to be relevant in construing what that exclusion means. Now here, in both of the cases of performance transport and the Gill case, a business bought a policy to cover any pollution incurred during their core business activities. One case, the business was a restaurant, the other was a petroleum transporter. Both courts declined to read the exclusion in a way that would vitiate the very coverage that those businesses thought they were buying. Now,
before your time runs out, I want to make sure I understand what you were saying earlier. You're saying that the costs of removing the soil are covered, but everything that happens after the soil is removed, all the treating of it and getting someone to take it, all those costs are excluded and are the responsibility of your client.
If those cleanup costs occur off-site, then it is excluded. You need to give, there needs to be meaning to the word thereafter. And I think it's very important, again, to look at endorsement 9 before my time runs out and note that the phrase "and thereafter removed" is not an incidental, meaningless word as argued by Great American. It is in fact deliberately used 3 other times in endorsement 9. It has to have a meaning under Massachusetts law. It can't mean, Great American simply argues that its meaning is quote modest, I think they call it. But the problem is the law in Massachusetts presumes otherwise. It presumes every single word in an insurance contract must be given some meaning and purpose. Great American is arguing that simply means thereafter simply means the soil is removed after it's excavated. Well, of course, you can't obviously excavate soil before you remove it, or you can't remove soil before it's excavated.
Counsel, your time's up. What's the difference between soil and sediment?
I don't think that's relevant for the interpretation of endorsement 9.
Well, sediment is in endorsement 9 without the word thereafter. So what's the difference between soil and sediment?
I would have to harken back to my science courses that were taken over 25 years ago. So I don't think I'm in the best position to answer that. In this case, I know we were dealing with contaminated soil. I don't know that we were dealing with contaminated sediment.
Okay.
I see that my time is up. I'm happy to answer any other questions.
Thank you very much. I see none. We will hear from Attorney Ruggieri.
Thank you, Your Honor. James Ruggieri for Appellee Great American E&S Insurance Company. Your Honors, I would like to address 3 points with the court's permission. 1, the docketing of the judgment briefly. 2, DIV's reliance on the First Circuit's decision in performance trans. And 3, I do want to talk about which issues are properly before the court and which are not.
Don't leave out the question of what thereafter means in
No,
the exclusion at issue.
I think, Your Honor, thereafter, you could have a situation where contaminated soil is not removed. You could have that situation. Would they have received the approval from the authorities?
But what does thereafter add to that phrase?
I think
obviously it can't be removed unless it's excavated or disturbed first.
Correct, Your Honor. I think it's a clarification of temporally what happens. You excavate soil and then you remove it. I think it's
why is temporal clarification needed? It's only logical that it can proceed in one order, isn't it?
I think it's logical that it can only proceed in one order, but I think that a clarification that makes that logical point doesn't mean that you're not giving effect to the progression of excavation and then or thereafter removed. I think grammatically, it hangs together. And one of the issues that I would say, Your Honor, is that you have to read endorsement 9 in conjunction with section 4 of the policy form, which is the section form for exclusions. And what those do when you read those together is that you see that there's a juxtaposition of cleanup costs on the one hand, and contaminated soil that's excavated and thereafter removed because of site development on the other hand. If contaminated soil is excavated and thereafter removed because of site development, then the exclusion is pretty clear. All cleanup costs based upon, arising out of, or related to the contaminated soil is barred.
Okay, so can I ask you the opposite of the question I asked Attorney Pickering Cook? We excavate a bunch of contaminated soil.
Yes, Your Honor.
But somehow it's able to be treated on site. Maybe the site is huge and we bring in some kind of complex equipment that is able to neutralize whatever the contaminant is. Or maybe it can be filtered in some way. It's quite expensive, but it can be done on site. And then the soil is replaced back where it was excavated from. That is covered. Do you agree?
It is covered, Your Honor. It's soil that was not removed, correct.
Okay. So the excavation cost is covered?
Yes.
And the treatment cost?
Yes, Your Honor. Yes, Your Honor. Right. Soil that was not removed. It's covered.
This is putting aside the next exclusion that's checked on the box, contaminated soil that's treated in any way.
It is, Your Honor. It is, Your Honor.
All right. So now, we dig up that same soil. We look at it. Maybe we try to treat it on site. But we realize, wow, that didn't get all of the oil, radiation, asbestos, whatever the heck is in it, out. We've got to ship this off-site and treat it. All right, guys, back the truck up. Here we go. And now it's taken off-site. It seems that both you and your sister are in agreement that the costs that accrue after that for treating it or for decontaminating or whatever, dumping it, whatever's done to it off-site, those are not covered.
Correct, Your Honor. I agree with that.
So it seems like all we're really fighting about here is whether the excavation costs are or are not covered. And what I'm trying to figure out is, since it refers to soil that is thereafter removed, this soil isn't soil that is thereafter removed until it drives off the property. So is the excavation cost, where it turns out what you have to do is off-site, is that covered or not covered?
Your Honor, the key to whether it's covered or not covered is whether the contaminated soil is removed by the language of the endorsement.
Well, I agree with that, but before it's removed, it's not contaminated soil that has thereafter been removed. At the time it's dug up, it's just soil.
It's not, Your Honor, soil. But cleanup costs actually cover or include the pre-construction investigation of pollution conditions. So it is a situation where whether in fact it's covered or not covered is dictated by whether the contaminated soil is ultimately removed from the property. If it's removed, then none of
the day the excavation takes place, it's Schrodinger's cat. We've got this soil. we hired a truck to come and dig it up. It cost $8,000. They dug it all up. But that, whether that's covered or not, depends on something that hasn't happened yet, that's going to happen in the future to this soil that we may not even know at the moment we dig it up. Is that
Correct.
right?
Correct, Your Honor. That is right. That is the way the policy works, and the coverage is for pollution conditions. And as I said,
And is that because in your view, the excavation arises from?
Certain,
or why?
Certainly.
Because if you're able to treat it on site, you're going to cover the digging it up.
Yeah, absolutely, Your Honor. And from an insurance perspective, when you have a site development exclusion, identified site development exclusion, plainly what was being underwritten is the insurance company did not want to underwrite the risk and the cost of the costs incurred with excavating and removing soil.
But you don't know that you're not covered. When you excavate, you may not know. Again, to some degree, I feel like there are factual questions here that may bear on the meaning of this. That is, that it's ambiguous to some degree. What about the excavation cost? I don't think the word thereafter does anything for anybody. It seems like an emphasis or something. But logically, if it's costs arising from soil that is removed, present tense in the thing, thereafter removed, so actually past tense maybe, then the costs begin to arise when it's removed. Now it's the soil costs arising from this soil. Now, while it was still on site, it wasn't. Do you see what I mean? And I feel like I would need to know more about, well, how do you clean up soil? Are there two separate steps? Is it one thing? Do you know? Why aren't there factual questions about what actually takes place in a cleanup site that might be necessary to figure out? It's odd to cover the excavation costs if you can clean it on site, but not if you have to take it off, it seems to me.
Your Honor, it's not odd because this is not a duty to defend situation. So we're not talking about a duty like that. This is a situation where it's an indemnity obligation from the carrier under certain conditions. So it's not unique at all that
but
you
it's supposed to be
construed
now. It's supposed to be construed narrowly, I'm not saying, to me, it seems like there are practical questions here. So each of you says a little something about where the real cost is, but I don't know where the real cost is. And asbestos may be different from oil or radiation or toxic chemicals, right? Toluene or something. I have no idea.
We do know, Your Honor, that the endorsement is sort of looking backward at the conclusion because it talks about excavated and thereafter removed. So in terms of determining whether there's coverage under this policy, one has to know whether the contaminated soil actually is removed. And that's the way it's set up here. And Your Honor, it's also not a situation where there's some uncertainty about what costs are being sought here, because DIV tells us the cost that it's seeking coverage for in its complaint at paragraph 1. It says it's seeking coverage for, quote, costs that DIV has incurred and continues to incur for the investigation and cleanup of asbestos-containing waste materials.
Can I make sure I understand your argument?
Yes.
So if the soil is tested,
yes,
and excavated and dug up, then a decision has to be made. Can we deal with this on site, or do we have to remove it from the site? And DIV would then look at its insurance policy and say, under this exclusion, if we remove it, then all of the costs related to that soil seem to be excluded. If we can deal with it on site, then they're not excluded. So if this box is checked, excluding costs in the case of soil that's removed, DIV has an incentive to try to deal with it on site. If the box is not checked, then obviously DIV has paid more of a premium so that that box won't be checked, but it'll be covered for the costs related to that soil if it's taken and buried in some landfill
And that's correct, Your Honor. We do have the check of the environmental authorities, which played their role here in the permitting process, and they had to approve the plans to develop the property, and the plan was to excavate and remove the contaminated soil. So I think we knew up front what was going to happen here, and in fact, now we appear to be at the back end where it did happen. This is contaminated soil that was excavated and thereafter removed from a covered location because of site development. I mean, it falls squarely within the wheelhouse of the words of the exclusion. I think the Superior Court actually absolutely got it right. Your Honor, I would like to touch a little bit on.
I'm sorry, Judge Ditkoff has a question.
I'm sorry, Judge Ditkoff.
The clock just reset, but we'll figure that out. I'm not following this, and let me explain to you what my problem is. We find some contaminated soil on a building site, and it would seem to me that the two things you could do to that is you could treat it or you could remove it, both of which, under your reading, are excluded. One under what we're talking about and the other on the contaminated soil that is treated in any manner exclusion. Is there something else you can do to contaminated soil on a building site other than treat it or remove it?
Your Honor, I don't know that I know the whole host of things that one could do, and I don't think this would meet with regulatory approval, but we did hear the argument that you could, move it over to a different part of the property and leave it on that property.
Or maybe it's a small amount of soil and you could encapsulate it somehow in some 10,000 year container.
And that was the other point I was going to make, Your Honor. Thank you, Justice Sachs. That it was the other point that I was going to make. Your Honor, I don't think we need to spend a whole lot of time, but with regard to the court's ability to consider the merits of the appeal, the Swampscott case and Justice Sachs, I did look at one of your cases, Liberty versus Casey, and even there you noted exactly what you said here, which is that the question is whether the appellee has raised an objection and whether the appellee has been prejudiced. We're not raising an objection. We don't believe that we've been prejudiced and aren't arguing for prejudice. The performance trans case, Your Honor, completely different. One, First Circuit cannot change Massachusetts law. Two, the Superior Court did not rely on that case. We brought the district court's opinion after briefing, but before argument. The Superior Court didn't even mention it. The Superior Court relied on the Supreme Judicial Court's ruling in the Bond Brothers case, which held an exception to a contractual liability exclusion could not create coverage that was barred by the faulty workmanship exclusion. And you saw from our papers the quote that the court was very resoundingly clear on the rule in Massachusetts. I would point out, Your Honor, that DIV, until the First Circuit's ruling, agreed that the Superior Court got it right. It actually admitted the Superior Court got it right at page 41 of its opening appeal brief, where it said the trial court correctly concluded that endorsement 12, the asbestos exclusion, as an exception to an exclusion, could not operate to negate the import of the site development exclusion. DIV knows what Massachusetts law is in this point, and it knows that the Third Circuit got it right. A couple of other things in terms of what they raised down below, and I think this is important because, Your Honors, on other cases that you said have been very clear that parties cannot raise issues that they didn't raise below. What was the claim that DIV made down below? They told us in the papers they filed down below. Record volume 2 at page 30. This is their words in opposition to my motion. Quote, the parties do not dispute that at issue here is coverage B. They made 3 arguments in support of coverage under coverage B, no mention of A or H or anything else. They said asbestos is not a pollutant. They said an exception to exclusion can carve back coverage. And they said because of that, they had a reasonable expectation, if nothing else. As the Superior Court said, they conceded that asbestos is a pollutant at oral argument on the motion for judgment. And at page 41, they conceded that under Massachusetts law, exceptions to exclusions cannot carve back coverage that would otherwise be barred by another policy exclusion. Judge, they go after the Superior Court and say that they actually seek damages that aren't barred by the site development exclusion. They cited a record site, and I went back at record 2 at 69. That's a case, that's a letter they sent my client 6 months after the Superior Court made its ruling on my motion for judgment. This is what they said in paragraph 1 in terms of the damage they're seeking in this case to the Superior Court. Costs that DIV has incurred and continues to incur for investigation and cleanup. Not until this court, and not until this appeal, did DIV ever say that the Superior Court didn't resolve all the issues it presented down below. And not until this appeal did DIV ever say that the Superior Court didn't address all of the damages claims that it presented down below. Now they want to talk about other damages. They want to talk about A&H coverages. DIV's prior counsel didn't make them. We submit for good reason. They don't apply. But just because new counsel's brought into the case doesn't mean that they get to violate the rule that you can't make new arguments on appeal that you didn't make below. And Massachusetts law, again, couldn't be clearer on that. The panel, your honors, have sat on other cases where you made it very clear, 27 Ramsdale, Sigilin Inc., Froyle Management Group. If DIV didn't make the arguments down below, they can't make them here. If they want to pursue these new arguments, I guess they can file a separate action, and then we can have a fight over whether they can make these same arguments in a different action, and if so, whether they lack merit. But the issue for today is if they didn't make them down below, they can't make them here. Thank you, Your Honors.
I think we understand your argument. If there are no further questions, thank you both. Excellent arguments, interesting case. It is submitted.
Thank you, Your Honors.
And bearing in mind that we remain live, why don't we take, if there's no objection, a 7-minute break till noon? And I'm going to just mute my camera and microphone so that we'll keep this same live stream going, only so we don't run into that problem. Yes?
Sounds good.
Hello, everybody.
Hello.
Eric, are you there?
I am, Judge, and I'm ready to admit counsel for the next case when you're ready.
Let's do it, unless we all good, guys? Thank you. Yes. Good morning, Council. Due to a technical difficulty we've been having with streaming, you should be aware that although we are not recording yet, we are streaming live even now before the argument begins. I would just remind you that your cameras and microphones may be on throughout the proceeding. I gather that that there will be only one oral advocate for each side. Is that correct? And the others are okay. Attorney Ellsworth and Attorney Krasinski, can you both hear me?
Yes.
Very good. So when we begin recording, I will call the case and explain the rules, and we will move forward.
I think we have an echo.
If one of you has on the live stream, could you please turn it off, as that can create a feedback loop? Let's give it a go. Whenever the clerk's office is ready.
And we are recording.
Thank you very much. Good morning, everyone. Afternoon, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am joined today by Justices Sachs and Ditkoff. The next matter we will hear is number 20-828, Allegaert and others versus VIEW Hotel Owner LLC and others. And we will hear first from, I should say, the rules are the same as they are when we meet in person. We're, of course, doing this by teleconference due to the pandemic. It's 15 minutes per side and there's no rebuttal. And we will hear first from Attorney Ellsworth.
Good afternoon, and may it please the court. There are two issues in these consolidated appeals, both of which require reversal. The first is the dismissal for lack of jurisdiction of the appellant's appeal of the Zoning Board of Appeals grant of a special permit to the Harborview Hotel. And the second is the dismissal on res judicata grounds of the appellant's separate enforcement action pursuant to 40A Section 7. Let me start first with the special permit action. The only relevant question in that action is whether my clients were entitled to Section 17's 90-day appeal period, because the allegation was a lack of notice of the special permit proceedings in front of the Zoning Board of Appeals. All we have to do in order to avail ourselves of the 90-day period is to allege a defect in the notice of the public hearing. We alleged two.
I see that you did allege a defect in the mailing of the notice, and I see that you filed it within 90 days. So assuming we agree with you that satisfies the jurisdictional allegations and that it was error to dismiss the claim as to defective mailing, you've also raised a claim that the content of the notice was defective. How does that fit within the 90-day provision of 40A-17, which seems limited to defects in the publication, mailing, or posting?
Sorry, I'm just looking for Section 17. The language of Section 17 relates to the validity of an action with respect to publication, mailing, or posting. Our defect in the content of the notice goes to all three of those, to a defect to all three forms of notice, because the content of the notice didn't sufficiently put anybody who saw the notice, or make them aware that of the nature of the action. And in fact, we contend it was misleading, the notice that issued, in the way it described the proposed action.
But if mailing was improper, why should you get more time to challenge the content of the notice than someone who doesn't allege that mailing was improper? I mean, if you succeed on your improper mailing claim, then presumably the board had no jurisdiction, if I understand it properly, and they have to start over somehow, and they can fix whatever defects in the content they think they want to fix. But I'm not sure why a defect in the mailing would allow you more time to challenge the content of the notice than someone who is subject to the ordinary 20-day rule.
Well, I think that a defect in notice can take more than one form. Certainly, we've alleged mailing defect, but the content defect is similarly, the purpose behind allowing a slightly longer period where there is a claimed defect in notice is equally served by allowing somebody who didn't realize what in fact was contemplated because of a defect in the content of the notice. And then after an approval and something either started to be built or an action was taken, realized in fact the true gravity of whatever the action is that was taken. So it seems to me that the way in which the notice provision works and the 90 days that's permitted for defects in notice applies equally to a claim defect in the content of the notice as it does to our other claim, which is that the mailing was defective. Either way, I think the court was wrong.
How is count 2 timely? Count 2 just challenges the decision on the merits and the special permit. Do you agree that that is untimely?
Count 2 in the amended complaint was the declaratory judgment claim, I believe, Your Honor. And yet there's no question that we did not, because we didn't have notice, that we did not appeal within the 20 days. So it's really, it is the notice issue that is before the Superior Court. I don't believe that it would be open to the Superior Court if the case goes back on remand or if it hadn't been dismissed to reconsider what the Zoning Board of Appeals in fact did. I think what the proper result when there's a defective notice is to vacate the Zoning Board of Appeals action and send it back to the board.
So you agree the dismissal of count 2 was proper?
I agree that I agree that that was untimely and it doesn't allege a defective notice because it relates to the actual actions of the ZBA. Okay. But as to count 1, what the Superior Court did was rather than, it dismissed it jurisdictionally under Rule 12b1, but did so essentially by not accepting the facts alleged as true and instead by crediting an affidavit of the town administrator that was in fact not even submitted in connection with the motion to dismiss. It was submitted earlier and on the docket in connection with the motion for a preliminary injunction. That affidavit doesn't go to the defect in notice that we allege, right? That affidavit says that the administrator followed her usual procedures in mailing notice to the abutters list and appended the abutters list. But the claim in the complaint is a failure to receive that notice and enough people that failed to receive that notice that we say this calls into question whether the notice in fact was effectively mailed. What the Superior Court effectively did was to decide on the merits, the ultimate issue at the 12b1 stage, which was improper and is the basis for our reversal here. In terms of what the Superior Court did on our claim of defects in the content of the notice, the Superior Court, again, did not accept the allegations of the complaint as true as it was required to do, and instead went on and concluded that the contents of the notice were sufficient to put anybody who received it or who viewed it on notice of the proposed action. I'd point the court to Appendix 1, pages 299 to 301, which are photographs of the actual structure that was built, which is part of what we would have sought discovery on and part of what we would have put on in our proof of how the content of this notice, which described a smaller structure, was in fact misleading as to the actions that the hotel ultimately took. But again, the Superior Court decided all of that at the 12b1 stage based on attorney argument as to the content, not based on any extra record material at all, rather than, as he was required to do, accepting the allegations of the complaint.
Is there some case that tells us what level of detail the notice of a public hearing has to give? I mean, it seems to me that it identified the hotel. It said constructing a bar of so many square feet in a new location, and that the plans and application are on file with the town clerk and the building inspector or the zoning board of appeals. I can't remember which. Is there some case that says the notice has to do more than that?
The Carson case, Your Honor, indicates that the notice must be sufficient to warn neighboring landowners of proposed action that may affect them injuriously. I think
so. Why wouldn't this notice saying we're putting in a replacement bar at in a different location be sufficient to warn the neighbors that this could have an impact on them?
Because the notice, in fact, is misleading. It's not just that it's incomplete. It does have the address. It says that there is a movement and it provides square footage, but that is actually a misleading description of the action ultimately taken by the hotel. There was nothing in the notice that would have put anybody who viewed it or received it, or it would have made them aware of the magnitude of the change that's being requested. Or
well, let's suppose that the action requested was, we want to move the bar, but we're going to confine our service of food and beverages to the pool area, quote unquote, as defined in the 1992 special permit. That is the rectangle immediately surrounding the pool, not the area between the pool area and the green, so-called, where the new bar is located. So no change in where service would be located, just a change in the location of the bar itself. Would this notice have put neighbors sufficiently on notice of that, or would it still have been defective?
I think it would have been closer because it indicates that it is moving to a different location and then sort of implies that it's moving to a different location within the pool area. So I think that those circumstances would be a closer call. What the notice here did, in addition to as I've stated, being misleading about what actually was being done, it did not provide the neighbors with sufficient information to know that, in fact, the impact on the surrounding properties was going to be of the magnitude that it has been, but either in size, in specific location closer to the abutting residences, or in any other information that would allow the homeowners to understand.
What's your best case for the notice has to describe the impact of the?
It's the Carson case, which may affect them injuriously, Your Honors. And again, I think, let me just take this back to the original point, which is what we have done here is alleged a defect in notice. This question about whether the notice was in fact sufficient, whether it was would put a reasonable person on notice about the impact it might have on their property, those are questions of fact that would have come out in discovery, and that we could have been put to our proof if we'd been allowed to proceed past the pleading stage. So I do think that the premature dismissal of this is part of the challenge in understanding whether the notice was in fact sufficient. I would like to move to the second argument because I see my time is running short, which is the dismissal of what I call the enforcement action pursuant to Section 7 on the grounds of res judicata. As the court is aware, a 12B1 dismissal or a dismissal for lack of jurisdiction does not have preclusive effect for purposes of res judicata. So that in and of itself is a reason to reverse the Superior Court's judgment in the enforcement action, which indicated that this claim was barred by res judicata. I would also note that the Superior Court went on, again, I think the res judicata is sufficient, but went on to—
No, but he has had three grounds, and res judicata was only one of them. The other ground developed at greater length was that the 2019 special permit didn't authorize any, if I'm getting this right, substantively, the action that the hotel was undertaking was not inconsistent with the 2019 special permit, that it authorized some use in addition to the mere construction.
That's correct. The court did say that, and there are two reasons why that's incorrect, I believe. The first is there are two references or the word use appears twice in the 2019 special permit, and that's at Appendix 139. The first is it refers to an existing non-conforming use. That, of course, does not relate to the use that was going to be made of the structure. That relates to the hotel itself, which is an existing non-conforming use in this residential neighborhood. And then the word use appears again, the next sentence, which indicates that the bar will not result in a significant intensification in the use of the structure. Again, the structure there is the hotel, which is the non-conforming use. So I think that's just an incorrect reading of the special permit.
But can the ZBA grant relief that is broader than what's requested? So let's say that we construe the application as granting permission, as seeking permission only to build. But can the ZBA implicitly or explicitly say, well, you're not going to build this thing without using it, so we're going to approve it for building and use? If that was done explicitly and on the record, would that be permissible?
Right. I don't think that's what they did. If they had, I think they would have another failure of notice, because there's certainly no contention that any notice was given that the 1992.
Isn't it implicit when you construct something that you're going to use it for the purpose for which it was built?
Well, and this goes back to the question of what, in fact, the ZBA had before it in 2019. The ZBA had before it the 1992 special permit, which both it and the applicant referenced which is confined to the pool area. So the ZBA may have thought that it was not going beyond what the 1992 permit allowed. The ultimate construction is outside the pool area, as we've shown on the maps, and that is what Section 7 exists to address. It is a use that goes beyond the permit that's allowed, assuming the validity of the 2019 special permit and the 1992 special permit.
You're saying the ZBA didn't know where they were going to put the pool bar?
The ZBA indicated that the pool bar would be in the pool area, and that's simply not where.
Wait, but usually when you get a special permit, you give the town a plan of where you're going to build and what it's going to look like. Are you saying that didn't happen here?
There was a plan, but the plan that was submitted is not the same plan that it doesn't have the sort of hash marks that are in the 1992 special permit area.
I get it's different than the prior permit, but they got a plan that showed we're going to build a pool bar here in this place, and the ZBA says you can do that. So doesn't that suggest the ZBA is also saying you can at least sell drinks from that bar?
I don't think that's what the ZBA did. I think the record in front of the ZBA, the hotel's attorney indicated that the 1992 permit would continue to govern. The zoning bylaw under which they moved and the ZBA cited related only to construction and only to structures and not use. So I don't think.
Let me make sure I understand. So you're saying it's because there's some earlier permit that we don't just assume that the permit allows the use of what you're permitting? Or are you saying that special permit generally doesn't allow use, just construction?
A construction permit allows construction, and there are separate provisions that relate to use.
So if I get a special permit to finish my basement, I can't use it. I can finish it, but then I can't go in it and do basement stuff with it.
Well, I think you probably can use your basement, but that's different than what the hotel has here. The hotel needs.
Why can I use my basement if the permits are only for construction and not for the use for what you're constructing it for?
Because the zoning bylaws don't allow the hotel to conduct outdoor service of food and beverage in this residential area, absent a special permit. They need a permit for use. They also need a permit to construct or to change a non-conforming structure. So they need both because of the nature of the zoning in the district in which they exist. And the use that's allowed in the 1992 permit doesn't extend to the use that's being made today, given the location.
Yes, one more question. If that's true, if the 2019 special permit only allows the construction of a bar, but not any use of it, then how are your clients aggrieved such that they can sue to challenge the special permit in the first place?
Well, the challenge to the special permit, they were aggrieved as parties with notice that something was being moved closer to them. They did claim construction noise as part of the agreement, so the actual structure. But the hotel could make use of that structure that is different than the outdoor service of food and beverage, right? There are other uses that can be made on that property. It is the combination of outdoor service of food and beverage with this new location that creates the tension that gives rise to an action under Section 7. I see my time has expired, but if there are other questions, I'm happy to address them.
I'm sorry, I'm muted. Thank you very much. Your time has expired. I see no further questions, and we will hear from you now, Attorney Krasinski.
Good afternoon. May it please the court, Mariana Krasinski for the appellee Harborview Hotel Owner LLC. Now, the appellant substantively only challenged the Superior Court's dismissals of two suits. Judge Ricardona's dismissal of the special permit action and Judge Davis's dismissal of the enforcement action. As it concerns the dismissal of the special permit action, I believe that there are two principal issues before this court. First, whether the Superior Court applied a proper standard of review in considering the appellee's motion to dismiss for lack of subject matter jurisdiction, and two, whether the findings made by the court concerning the ZBA's notice were erroneous. Now, there doesn't seem to be a dispute that the Section 17 20-day appeal period is jurisdictional in nature, and that the failure to file an appeal within this appeal period deprives the court of subject matter jurisdiction over the zoning appeals. Now, appellants rely on the limited exception to the 20-day appeal period in cases where there are defects in the notice of the public hearing. Appellants claim that the Superior Court was required to accept as true the factual allegations in their complaint of defects in the board's notice. However, this contention is incorrect. In Callahan and Hiles, the two SJC decisions we cited in our brief, the SJC held that if a 12B1 motion is supported by an affidavit or other materials outside the pleadings, a court gives no presumptive weight.
But what makes the existence of a defect in notice a jurisdictional matter for purposes of a 90-day action, rather than the issue that has to be determined on the merits of the 90-day action?
I believe the timeliness of an appeal is a jurisdictional issue.
Timeliness, yes, but surely they filed within the 90 days and they alleged a defect in notice. The purpose of the 90-day proceeding is to determine whether there is such a defect in notice. And do you agree that if there is a defect in notice that the board was without jurisdiction to act, so its action would have to be vacated?
Well, it depends on the circumstances. I think that if there was a complete failure of notice, then the board would have been without jurisdiction. But in this particular instance, we've relied on the affidavits submitted by the board administrator, Ms. Morrison, who had alleged, who had provided the information.
Okay, so you're getting back to whether it's, so you contend that the existence of a defect in notice is a jurisdictional fact. Why is it not the issue that has to be determined on the merits of a 90-day action?
Well, I think that this is a prerequisite for the appellants to be able to be heard on their zoning appeal. So it is a jurisdictional issue.
The purpose of the 90-day action isn't it to determine whether there was a defect in notice? Can they get anything else adjudicated if they establish a defect in notice?
They could. I think section 17 allows them to do that. So long as they establish that there's a defect in notice, they can allege the other basis for bringing their zoning appeal. However,
why didn't the SJC say the opposite in Cappuccino? They said it's not to enlarge the time for filing an appeal on the merits.
No, but they can allege the other defects that they claim that the ZBA had, or the other errors they claim that the ZBA had made in the action, which is timely brought under the 90-day exception.
Why is that? Because Cappuccino seems to say the opposite, that all you can raise in a 90-day action is the notice defects and not the problems of the special permit, which is what your friend agreed to.
Yes, well, I believe that the Cappuccino case is not applicable here, at least with respect to the standard of review that the Superior Court was required to use, because it was not a 12B1. It was not a decision to dismiss on the basis of the lack of subject matter jurisdiction. But I do agree with you, Justice Ditkoff, that there is this language in Cappuccino which suggests that that a mere allegation of a defect may be sufficient, except that the standard of review of 12B1 motions specifically requires the Superior Court to adjudicate jurisdictional defects.
But isn't the jurisdictional fact whether it was alleged, as to which there's no dispute here? The jurisdictional fact is there an allegation of a defect in notice? If there is, now we have jurisdiction, and then we have a merits case called, is there a defect in the notice? And we don't do it on affidavits at a 12B1 kind of thing. We have a discovery and a trial. And
well, the SJC distinguishes between 12B1 motions supported by affidavits and those that—
I understand that, but my question is, why do you say the jurisdictional fact is, was there a defect? I thought I heard you just say that the SJC had said that an allegation of a defect is what allows a 90-day appeal. And there is such an allegation here.
Well, I don't believe the allegation of a defect is sufficient to withstand a motion to dismiss where that jurisdictional defect is challenged with affidavits by the moving party. I believe then the standard of review applicable to such motions to dismiss is triggered, and the Superior Court is required to adjudicate the jurisdictional predicate as it is brought on a motion to dismiss.
But isn't the jurisdictional predicate the allegation? A complaint that alleges X may be brought within 30 days. A complaint that alleges Y may be brought within a year. A complaint that alleges Z, now you don't win necessarily, but we look at the complaint, don't we, ordinarily? Now, if there is some underlying fact that has to be true before there's jurisdiction, okay. But I don't see why we would litigate at the motion to dismiss on 12B1 stage the merits if the allegation is what gives the court jurisdiction for 90 days, up to a 90-day appeal period.
Well, I don't believe that a mere allegation is always sufficient, even if you apply the 12B6 standard that usually gives presumptive weight to the allegations in the complaint. And in this particular instance, here's why. Section 11 only requires that notice be mailed and not that notice be received. In this particular instance,
well, the fact that 9 or 11 people didn't receive it, gives some plausibility and heft to the idea that something may have gone wrong with the mailing process itself, if you're getting at the Iannucchino standard. I wanted to ask, if we assume that the court improperly dismissed the special permit action and that it should have gone on to adjudicate whether mailing notice was proper, is the question of the content of the notice open in that action, or does it only go to whether the mailing process was proper?
I don't think the content of the notice should be at issue, because if the appellants claim that they never received the notice, they really don't have standing to allege that notice was insufficient or misleading. But regardless of that, we do believe that notice was sufficient, and the court that had the notice in front of it on the record was able to conclude as a matter of law that the notice satisfied the prerequisites, the requirements of Section 11.
Can I ask you about the enforcement action?
Of course.
Can the hotel serve food and drink on the green?
Yes, it can, Justice Rubin.
Why?
The 1992 permit specifically addresses the terms.
Okay, so it's under the 1992 permit. They can serve alcohol on the green and food on the green.
Yes, that's
correct. Can they serve it since the 2019 special permit issued? Can they serve it on the porch?
No, they may not, Justice Rubin, because the porch is not part of the pool area. And the 1992 special permit specifically prohibited the hotel from serving food and beverages on the porches.
Okay. What about the area where the new bar is located that isn't part of the pool area? Can they serve there?
Well, I would urge you to look at the 2019 special permit, which expressly finds that the new location of the pool bar is within the pool area, and that the hotel's operation of the bar from that area is consistent with what the 1992 allowed the hotel to do.
Where is that finding that it's within the pool area?
That's a heavy lift. Show me that.
Well, in point 1, so the A139 in the record is the decision of the Zoning Board of Appeals. And in point 1 at the end, the ZBA says that the new pool bar will be smaller in size than the existing pool bar and located on the opposite side of the pool area. I do believe that a fair reading of this is to suggest that the pool bar was being moved within the pool area.
Oh, well, if you look at the map from the 1992 special permit, it seems pretty clear about where the pool area is. It's a rectangle drawn around the pool, maybe out a distance of 6 or 8 or 10 or 12 feet on every side. And this new pool bar has been constructed outside that area.
Yes, are you referring to the plan that was attached, or that was attached to the application of the hotel in support of the 1992 special permit, or are you referring to the current one? Okay, well, so the hatched, well, first of all, there's nothing in the 1992 special permit that limits the hotel's ability to serve foods only to the hatched areas on that plan. In fact, the hatched areas also include the green, and it also includes the porches on which the hotel.
But it doesn't include the area where the new bar was constructed, does it?
It does not, but it also,
So
again.
how can you say it authorizes service of food and beverages in the area where the new bar was constructed?
Because it refers to the area as the pool area, and the hotel
It
has.
didn't ask for, you didn't, or the hotel, not you, the hotel didn't ask in 92 to serve there. They asked to serve in the hash marked areas, and they were told, except for the porch, it's fine. And you can even eat and drink on the porch, you just can't serve there, right? And so that's what was approved. So now we have an area where it is not approved. And my question to you is, under the 2019 permit, how much of that area is service allowed in? Is it allowed right where the bar is located? Is it allowed behind the bar further away from the pool? Is it allowed toward the pool? Where is it allowed exactly under this special permit?
Well, this is Rubin. So the hotel, together with its application, submitted a plan to the board, and the plan can be found at 81188. And that plan delineates the area where the structure will be located. It shows, the bluestone patio on which the structure will be located, as well as the additional furniture that may be put in that area. And this is part of the pool area as the hotel sees its own pool area. And this is what the ZBA, this is where the ZBA allowed the hotel to move and use the pool bar from.
I'm just trying to figure out, I'm looking at that page and I don't really understand. So where is it that you say food and drink can be served? The hashed area, the area behind?
What page are we on again, please? What page?
188.
I'm looking at 188, but I'm not sure I can really read this.
So the three dark shapes underneath the rectangular area in the middle, lower right, that say pool. Is that where the bar is being constructed? Because it's kind of blurry.
Oh, yes, I'm sorry. So I believe you look at the area that has these rhombuses on it. It's almost like the hatched area to the left of the pool. And it shows there's a structure, and it's called, I'm sorry, it is not very legible, but it does say bar in the middle of that hatched area. There's also, an oval depicting where the additional furniture and the fire pits would be located. And you could also see on this plan that there is, that this area is separate from the green lawn, and it's sort of part of the pool area as it has been used by the hotel in, in those years.
Why couldn't, this plan doesn't show any fence between the bar and the pool. Why don't the plaintiffs at least have the ability to challenge the fact that instead of separating the bar from everything else, you've separated the bar from the pool?
Well, because the hotel didn't actually separate the bar from the pool area. This continues to be a pool bar.
Is there a fence between the bar and the pool?
There's currently a fence between the bar and the pool.
So why isn't it open to the plaintiffs to say that when you built that fence, which I don't see in this plan, that you changed what the pool area was from what you had told the ZBA, and they're allowed not necessarily to make you get rid of the bar, but at least make it part of the pool area again?
I'm sorry, I guess I misspoke, Justice Ditkoff. There is no fence between where the bar structure is located and the pool area. I misspoke. So there's a bluestone patio that was extended, extended the pool area to where the structure is located, but there is no fence separating the pool area and the new bar.
I'm back looking at this 188. I'm just having a very hard time. There's someone has put a red box here. I don't know what that is. Do you know what that red box is on 188?
I do not, Justice Rubin, and I don't have a colored version of this plan. So
there's a rectangle. There's the hashed area.
Yep.
And then there's a big rectangle, slightly bigger rectangle sort of around it. I don't know what all these oval shapes are, frankly.
Trees.
I see. And so where is it that you say they're allowed to serve food and drink?
Well, they're allowed to serve food and drink around the area where the new pool bar is located and the entirety of the pool area.
Well, the The pool area, in my view, was delineated by the hash marks in the 1992 application. Okay, so outside of that area, where are they allowed to serve now?
But they're allowed to serve in this area that is delineated in the hash marks on the plan, which is where
The hash marks only, that hash mark area only.
not only there, but also in the entirety of the pool area as
The old
as they
pool
were
area,
allowed.
okay, but I'm just trying to figure out, the problem I'm having is this. There's, and your time has expired, but I'll ask you. There's a claim, your claim is, and the ZBA says, oh, this authorizes a food and drink service as well as construction of the bar. But when they've authorized it before, they've been very precise about where it could be, what the conditions are, what hours it could be. The hours were different depending on the area. And I can't figure out from this special permit which conditions apply. Do the green conditions apply to this or the pool area conditions? There are different conditions on each, right?
That's correct, but
All right, which ones apply to the new area?
The same conditions that the 1992 special permit extended to the service of food and beverages in the pool area, not the green.
Why do you say that rather than the rules about the green area?
Because the board specifically incorporated the 1992 special permit and found, I believe, found that the new structure will be located in the pool area. And that the events on the green are not necessarily related to the operation of the pool bar. These are certain specific particular events that the hotel holds for its guests and on only several times a week.
Okay.
Can you
I'm sorry, I'll let.
So on page 299 of volume 1, you have a picture here. Is that gazebo thing the bar? Where's the bar in this picture? If it is in here at all.
I guess you could call the gazebo is the bar, yes.
Okay, so where's the pool? Behind the gate?
Yes.
Behind the fence you just told me didn't exist. Is that what you're saying?
I believe that the fence doesn't exist, but
Okay, is this picture inaccurate? I mean, I'm seeing a fence. All right, sorry, you obviously do not have that information and it isn't, that's fine. But that's the gazebo. That gazebo thing is the bar and the pool is past that white thing, whether that white thing exists or not.
that's correct.
Okay.
Is that correct? That's correct. Okay. All right, your time has expired. Excellent arguments for both sides. Thank you both very much. An interesting case. It is submitted.
Thank you, Your Honors.
Thank you, Your Honor.
All right, judges, and we have counsel for the next case when you're ready.
We couldn't be more ready, gentlemen. Yes. All right.
All right, I'll admit them.
Good afternoon, counsel. Just for your information, due to a technical difficulty we've had, we are already streaming live, even though we have not started the argument. Can each of you hear me?
Yes.
Yes, Your Honor.
Excellent. When the clerk's office begins recording, I will call the case. You should be aware that your microphones and cameras will be on throughout the proceeding, which will be streamed live for the public to see. It is, in fact, already, and which will, an archived copy of which will be put up on our YouTube page so the public can watch later. So when the clerk's office is ready and says we're recording, I'll call the case and tell you the rules and we'll keep moving.
And we are recording.
Good afternoon, everybody. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Sachs and Ditkoff. The next case we will hear is number 20-962, Piva versus Middlesex Sheriff's Office, and others. The rules for argument are the same here as they would be in person in the court, which is to say 15 minutes per side with no rebuttal. And we will hear first from you, Attorney Ron.
Thank you very much, Your Honor. This case is about the meaning of the concept law of the case as applied to a motion for summary judgment brought by the defendant appellees on exactly the very same issue they brought in their motion to dismiss before the Superior Court in 2017. The judge denied their motion to dismiss on this issue. And while we had argued two things, equitable tolling and continuing violation, the court basically relied on the SJC case, Cudyer versus Stop and Shop Supermarket, 434 Mass 521. Now that case is important here because we believe our case is on all fours with that case. On page 536 of that decision, the court distinguished Title VII from Chapter 151B. And basically it said it had a different statutory scheme. There was an express delegation to the MCAD to act forcefully. There was deference to the MCAD. And most important, Chapter 151B is to be interpreted liberally. The Cudyer standards for retaliation, which is the whistleblower case is the functional equivalent of, is that there has to be a single act within the statute of limitations period and a single act outside of the statute of limitations period. And importantly, the delay was not unreasonable. And on page 541, the court said that the issue of continuing violation should go to the jury. Now, the Whistleblower Act, on the other hand, does not have an administrative scheme. There's no exhaustion of administrative remedies. There's no place to file a whistleblower complaint. There's no investigation process. So, but the important here is that the standards of the Whistleblower Act are interpreted to be the same as it would be under 151B. Now, if we apply those standards to this case, if you look at the affidavits of Richard Piva in volume 1 of the appendix, pages 192 to 209, and Carol Piva affidavit in volume 2, pages 43 to 52, and also take a look at the notes of the investigation, so-called, by the Middlesex Sheriff's Office, which for Richard Piva would be in volume 2, pages 36 to 52 on February 6th, 2013, and Carol Piva in volume 2, pages 137 to 140, which was on February 11th.
Mr. I'm not quite sure why those facts come into it when there's a letter in the record from November 27th of 2012, in which prior counsel for your clients lays out to the sheriff's office pretty clearly what the whistleblower claims were. Now, he may not have known of all of them, he may not have known all the details, but clearly everyone was on notice that those claims existed. But the action wasn't filed until, what, 2015, 2016?
The initial action was filed timely, Your Honor, in 2015 on June either 8th or 11th. I'm not sure which of the dates that.
Well, I don't know why that would have been timely, since it's not within 2 years after that November 27th of 2012 letter. Why should not the claim be considered to have accrued then when prior counsel wrote a demand letter on behalf of your clients?
Well, and as a result of the demand letter, they held an investigation, a so-called investigation.
But why does the existence of the investigation toll the time for filing suit?
Because they were hoping it could be resolved within that process.
Well, but when it's, 1 year and 11 months and 29 days have passed and the case hasn't been resolved yet, don't they need to file suit?
There's a 2-year period from when it would have been reasonable for them to file suit. And at that point, Your Honor,
why do you say when it would have been reasonable for them to file suit?
Well, Your Honor, at the time the letter was written in 2012, they had a different lawyer. And at that point, and after that, that lawyer left and they had to find a new lawyer. And they did find a new lawyer, Mr. Mazur. And Mr. Mazur is the one who filed suit in 2015 after this investigation had been completed. And
I'm sorry, I thought that you were arguing before us about law of the case. I thought you were not arguing that the statute of limitations had not run, but that the lower court was bound by its earlier decision. Am I mistaken about that?
No, you're not, Your Honor. But I was
so why are we talking about what dates anything happened on?
Judge Sachs asked me a question.
No, you were going at some length about what happened in 2013 and 14 and so on. And my question is that before us? Are we supposed to figure out when the statute of limitations ran or runs, and whether this is a continuing violation, or are we just supposed to be looking at law of the case?
The issue before you is law of the case, and that is on the basis of the judge's decision to deny the motion to dismiss on the theory that perhaps plaintiffs could prove a continuing violation. In order to prove that, a lot of evidence has to come in as to what happened when. And that was, I believe, Judge Sachs's question to me. And that's part of the process of figuring out whether there is a continuing violation. So that when you take a look at what was argued in the motion to dismiss, both by the Middlesex Sheriff's Office and by me, you will see that we argued continuing violation, equitable tolling, and the judge relied on the case of Cudyer. And Cudyer's—
Could you turn your phone? I don't know which of you has his phone on, but could you turn your phone off so we stop hearing these? That may be one of the judges too, whoever.
Could be email too.
Something is making a dinging noise constantly here. It could be, I don't know. All right.
Let me turn my email off. It's not my phone.
Okay.
But I'll turn my email off.
Thank you. It's just a little distracting. It's
server on. You can start pinging.
Oh, I see. Well, I hope I turned it off.
Okay. We'll give it a go.
Uh-oh, I lost you. Whoa.
We still have you.
Okay. You disappeared on my screen. Let me just say quit.
We still see and hear you.
Okay, well, I'll continue and hope that it doesn't happen. In any event, I want you to consider the affidavits of Richard and Carol Piva, which lay out that not only have we evidence that there was a continuing violation, but it's stronger at the time of the motion for summary judgment than it was at the time of the motion to dismiss.
Okay. But focusing on the law of the case issue, what do you say to the cases cited by the Attorney General's office on pages 16 to 17 of their brief, indicating that a second judge does have the power to rule differently from the first judge on a case, an issue, or a question of fact or law once decided in order to reach a just result? So I understand the cases about trial versus appellate courts and trial courts not revisiting issues that were decided or could have been decided in an earlier appeal. But here we have a motion to dismiss judge and we've got a summary judgment judge. Why don't those cases permit the summary judgment judge to take a look at the record and decide, nope, continuing violation is not applicable, and I'm finding this is time barred?
Two responses, Your Honor, to that. Number one, I hope you take a look at those cases, because in each and every one of the cases, it supports what we're saying. It's not that you can't have another motion considered, such as a motion for summary judgment. However, the issue is you have to find either a material change in the facts or a change in the law on that subject.
And let me ask you this, let me make it more practical. A judge at the motion to dismiss stage concludes that that the statute of limitations has not run, which is sort of what happened here. At the summary judgment stage, the argument is raised again by the moving party, the defendant. The second judge looks and says, why, this first judge made a terrible mistake. The statute of limitations had clearly run. This stuff is all 15 years ago. I don't know what he was thinking. And so they try to correct that error and say, I'm sorry, I'm going to rule summary judgment on that ground, even though it's different from what the judge found before. Now, if you're correct and the judge can't do that, that means we now spend all the money on a trial, and then on appeal, months later, thousands of dollars spent, they say, oh, by the way, this all happened 15 years ago. It was barred by the statute of limitations, and the appeals court in an unpublished decision says, yeah, I don't know what was going on with that motion to dismiss judge. He must have had a bad day, but that's wrong. How can it be that a later judge can't reconsider something that might be just really wrong?
Well, Your Honor, as you read the cases under law of the case, you realize that the standard is there should be deference to the original decision unless there was an error of law or a change in material facts. Now, the judge...
Why wouldn't assuming that's true, why wouldn't the circumstances that the judge at the summary judgment stage is considering a broader range of facts, that is not merely the allegations of the complaint, but the affidavits of the parties, and the judge is applying a different legal standard? Why isn't that enough of a change in the law and the facts to warrant the judge in deciding that no, the statute of limitations was missed here?
Your Honor, as you read the judge's decision on summary judgment and you read the transcript of the hearing, you'll realize that the judge did not and was not going to consider any of the facts detailed in those affidavits. And
okay, but my point is a little different, and I feel like your argument shifted a little bit. At first, you were saying there has to be a change in the law. I'm not saying there's any change in the law, and I'm not saying, as Justice Sachs suggested, that there's even new facts being considered. I'm saying there was an error of law by the first judge. The judge thought the statute of limitations had not run, but any sentient human being who really took 15 minutes and looked at it would be like, oh no, it's totally run. How can it be that a judge can't undo the mistake of the earlier ruling and end the case instead of wasting everyone's time when everyone in the room knows this is just going to be reversed on appeal?
Well, Your Honor, I would say to you that they wanted to, if we prevailed at trial and they want to take the issue up, they're obviously free to argue the original argument all over again. On the other hand, when you apply Cudyer and the principles of it and the standards, you would see that it would have been clearly wrong for the judge to take that position. It was not clear, and that's why under Cudyer, this continuing violation theory should be able to develop a record and go to trial.
Okay, but now you're talking about the merits, not about law of the case. Now you're saying, look, the first judge was right. And that's why I don't like this change, not because of law of the case, but because the second judge was wrong. But that's the merits, and you didn't raise that argument in your brief. You didn't say, and even if the judge could change the ruling, it was right the first time. It may have been, I don't really know.
Isn't that what we have to find out, Your Honor, whether when all the facts are developed, whether there was a Cudyer standard?
No, we have to find. I think our court has to find out whether law of the case prohibits the second judge from reaching a different legal conclusion than the first judge, I think.
And the cases cited by the defendant appellee clearly show that there has to be a clear, either material facts are different, or there was a change in the law. And in none of those cases did that happen. I mean, in all of those cases, there was either a material change in the facts, which supported a change in the decision, or a change in the law. But here, there was no change in the law. The law is, as the court, the SJC said in Cudyer, certain standards for determining continuing violation. The first judge on the motion to dismiss says, there's enough here to go find out more. Nothing more was found by the judge on this on the summary judgment case, she did not look at anything of those affidavits. She didn't consider it. And it would have been the defendant's appellee's burden to show her that, yes, we've now looked at the material facts and they have changed, or there was a change in the law. There was no change in the law. Cudger was still good law.
Okay.
I know my time has expired.
I understand your argument, and we will hear next from Attorney Boudou.
Thank you, Justice Rubin, and may it please the court. On summary judgment, the Superior Court dismissed the plaintiff's complaint as untimely. And as to that ruling, the plaintiffs acknowledge that they have made only a single argument in their appellate brief. They argue that the summary judgment judge should have been bound to the earlier reasoning of the motion to dismiss judge under the law of the case doctrine. In fact, the summary judgment judge fully complied with that doctrine, and so the judgment should be affirmed. The law of the case doctrine has both a permissive branch and a non-permissive branch. The non-permissive branch applies in a case unlike this one, where there has been some earlier appeal. And when that happens, the appellate court's ruling is, of course, totally and completely binding on later trial court proceedings on the same issues. The permissive branch of the doctrine applies when, like in this case, there has been no earlier appeal and a second trial judge has simply been asked to revisit or reconsider some earlier ruling made by a first trial judge. And when that occurs, the first trial judge always has discretion to decide whether and to what extent to revisit that earlier issue. That is true both under the cases cited at pages 16 and 17 of our brief that Justice Sachs mentioned, and it is also true under Rule 54B of the Rules of Civil Procedure. In this case, there was no earlier appeal. In addition, the issues were also materially different because the summary judgment motion was based on the documentary evidence, most importantly, the November 2012 letter, and the motion to dismiss argument was not. It was based only on the pleadings. And so for both of those reasons, there was no violation of the law of the case doctrine. The summary judgment judge was well within her discretion in reaching the limitations issue. The merits of the limitations issue have not been raised, and so the judgment here should be affirmed.
Do you agree with this proposition that to the extent that Richard is still suffering retaliation, he could file a complaint tomorrow alleging any acts of retaliation that happened after, what day is it, March 5th, 2019?
May 5th. Sorry.
What I'm trying to get at is, when you get new retaliatory acts, the fact that you could have sued about the earlier ones, does that bar you from ever complaining about any retaliation that happens afterwards? Or does it just mean, you get 2 years, so any retaliatory acts that happened in the last 2 years, you can challenge anything before that, you're out of luck?
I think it would depend on the precise nature of the retaliation claimed, Justice Ditkoff. If it were part of the same sort of continuing retaliatory hostile work environment theory, then I suspect it would be barred as a claim preclusion and res judicata matter. If we had a new theory of retaliation that doesn't arise from the same nucleus of operative facts.
How can it be res judicata if it hasn't taken place yet? You couldn't have brought it with your initial claim.
Well, this goes to the nature of a continuous adverse action hostile work environment claim, right? If the nature of the claim is that the hostile work environment that began back in 2011 is still continuing, then it might be barred. That said, if Richard's claim was that there was some new event, right? If Richard were fired by the sheriff's office next week, then I would agree. He could, of course, bring a new Whistleblower Act complaint and say, I think I was fired in 2021 because of my protected conduct in 2011. I don't think that kind of whistleblower claim would be barred. He could certainly do that.
I mean, I know it's not directly raised here, but I find this idea that they wrote a letter in one time and then somehow the clock begins ticking regardless of what kinds of retaliation are wrought against them in the ensuing several years, I don't understand. And again, well, not again, I haven't looked as deeply into this as I might have given the way this is presented. But if there were merit to Attorney Rahm's suggestion that there has to be a clear error of law in the continuing violation, about the continuing violation to allow ignoring, and I'll have to look at the cases about this, ignoring law of the case or, you know, reconsidering or whatever. How does that work? How can it be that writing a letter starts a clock that then sort of gives license for subsequent action by the putative defendant?
So the plaintiff's theory of retaliation in this case, really their sole theory of retaliation, was one of a continuous event. In other words, a retaliatory hostile work environment that consisted of multiple parts, but all together formed a hostile environment. And when that is the nature of the adverse event at issue, there may be parts of the hostile work environment that happened before the limitations period, and there may be parts of it that happened after the limitations period, but it is all untimely to the extent that the plaintiff was aware of the injury, aware of the hostile environment, and reasonably aware of his duty to assert his rights before the limitations period.
Let me push back on that. Let's say we have a female employee and she's subjected to constant sexual harassment, hostile work environment, naked pictures of women up, all that kind of stuff. And she knows she can sue. She decides not to. And then after 5-6 years of this, it's still going on. And she comes into court and says, I'm suing only for the last, whatever, I don't know what the statute of limitations is, only for the last few years of this happening. All the other stuff, I realize I sat on it. Is the employer allowed to say, look, you could have sued earlier. We get to keep doing this to you for the rest of the time you work here?
No, certainly the employer can't say that they're entitled to keep doing that. And certainly there may be other theories of liability that would apply in that circumstance. I strongly suspect there would be, but to the extent that the sole theory of liability is that of a continuous hostile work environment that began long ago, that particular theory would
so they can leave the one pinup that's been there the whole time, because it's a continuing violation. There's a dirty picture that one of the men in the office has put up on his cubicle that she has to see every day. And she doesn't sue. She writes a letter even. And years pass and she doesn't sue, and it's still there. That one can stay up forever. But new ones can't?
Well, none of the pictures should stay up.
That sounds right.
Is the right answer, Justice Rubin.
That sounds right.
And again, I think it goes to the type of employment case that the plaintiff chooses to bring. But if the plaintiff chooses to bring a claim that, in this case, he or she gave express notice of, and notice of his intent to bring in years past, then that claim does not then survive in perpetuity with the plaintiff having given express notice of the claim.
Seems like a hard line to draw.
I am content to rest on our brief with respect to the other arguments here. So unless there are further questions, I will end my argument early.
I see no further questions. Thank you both. Excellent arguments, very helpful to us.
Thank you.
Thank you.
Sorry, Judge, I know I have a timer up, but I'm fixing that right now. And we do have the attorney for the next case in the waiting room when you are ready.
We remain ready.
Excellent.
I speak for everyone. Can you hear us, Attorney Simi?
Yes, I can. Can you hear me okay?
Yes, perfect. Just to let you know, due to a technical glitch, we're actually already streaming live, although the case has not been called. So you should just be aware that your microphone and camera will be on throughout the proceeding. The clerk will begin the recording of the case, and then I'll call the case. These stream live so that the public can watch, and an archived copy of the argument will also be put on our YouTube page so members of the public can watch it later.
And with that, we are recording.
Good afternoon. Welcome to the Appeals Court. I'm Justice Rubin, and I'm joined by Justices Sachs and Ditkoff. The next case we will hear, our final case for the day, is number 20-888. This is a partially impounded case, so I would remind counsel to adhere to the order of impoundment and not use names and so on. It is captioned by initials YP versus KV. It's 15 minutes per side, but the appellee has neither filed a brief nor will the appellee be appearing, so we're going to hear only from appellant. You have 15 minutes, and we'll hear from you now. Attorney Zimi.
Good morning, or actually good afternoon, Your Honors. May it please the court. My name is Zahir Sami. I represent the defendant appellant in this case. There are two related issues that the court needs to decide here. One is whether there was any evidence of abuse as defined under Chapter 209A that could support the entry or issuance of an abuse prevention order against the defendant below. And related to that is the question of whether the abuse prevention order that actually did enter against the defendant was based on constitutionally protected speech and nothing more.
That second argument wasn't raised below, was it?
It was not. I believe it was not. In fact, my client was pro se at the time. I didn't represent her. So as you can imagine, it was not raised. In fact, I don't think there was really any legal argument really to speak of raised, given that my client was pro se. However, that said, it would still be improper to punish my client for any constitutionally protected activity, and that would certainly, it's sort of the flip side of the argument that there was no abuse here. All there was speech, and even if it wasn't raised, I would suggest to the court that this is an important issue that the court has discretion to address, even if it wasn't raised, given that, given how many 209A orders are filed in the Commonwealth every day, every week, every month. And I understand that, the judges who hear them face a very difficult task, all different sorts of disputes, like the one in this case appeared before them, conflicts of all sorts. In this case, there was essentially what was a housing dispute between two occupants of the same apartment, renting different rooms. And you can see from the record appendix that there was friction. There was some unpleasant interactions between the occupants of the apartment. The landlord got involved, and you'll see from the transcript of the lower court proceeding that the landlord actually was very actively involved and actually came to the hearing and testified at the hearing, even though he wasn't the plaintiff. But you'll also see in the record appendix, there's some emails from the landlord indicating that he was actually concerned about the unpleasant interaction between the individuals in the apartment, and that he was going to take legal action. But what it really comes down to is that there's nothing in the record attributed to the defendant other than speech. And the only speech that's attributed to her that is directed at the plaintiff, as opposed to other occupants in the apartment, or speech that was directed to the Better Business Bureau, for example, where she made a complaint about the landlord, or her statements that she would go to the police because she believed, rightfully or wrongfully, that there might be illegal activity being conducted by some of the
All
other
right,
occupants in the apartment?
can I ask you a couple of questions,
Sure.
counsel? Do you think there can be abuse warranting a 209A order without a person having put hands on another person or threatened to put hands on another person, or can that never be abuse?
I think that can be abuse, Your Honor. If somebody says, "Well, my father's a police officer, and guess what? He's going to beat the daylights out of you. If you don't do X, Y, or Z." That certainly could rise to the level of abuse and cause.
That's a direct threat of physical violence. I'm asking about, in the absence of either physical violence or direct threat of physical violence, can there be abuse?
Simply as a result of non-threatening.
I didn't say anything about threatening, non-threatening. I said threat of physical violence or physical violence.
It's hard for me to imagine that there could be, Your Honor. When you look at the definition of abuse under the statute, it says that abuse means attempting to cause physical harm or causing physical harm or causing somebody to reasonably fear physical harm. So, absent any threat of physical harm in your speech, it's hard to imagine a situation where the non-threatening speech alone could rise to the level of abuse.
Have you looked at Ginsburg versus Blacker?
I believe the name rings a bell.
So it's a case from this court. It seems like a very close case to me, where someone did something, pointed fingers in the face of it might have been his wife or ex-wife or girlfriend, something like that, and said other things, maybe said something like, I don't remember if it's the same case, but there was no physical contact. And I take it no words of, I am going to do physical violence to you. And the court found that it did count. It could support a finding of reasonable fear of imminent physical harm. And in this case, on June 22, 2019, at least according to the plaintiff, the defendant got in her face and threatened him. This is around the time, I guess, of calling the police about him moving her dirty dishes from the sink. And I'm wondering why that isn't adequate to support a finding of reasonable fear of imminent physical harm.
Can you, and I apologize, can you direct me to the record where that particular incident?
Yeah, I'm guessing it's in the affidavit, because that's the only place that any details are given. Hold on a sec, I'll have to pull it up. So, the appendix has this thing beginning on page 43, the facts that you received, the complaint 45 to 46. So hold on.
47 maybe?
Actually, I believe I found it. Yeah, right. You're right. Record appendix 47. I see what you're referring to, Your Honor.
Yeah.
So in that case, he does say that she got in my face, but he also says, "Do not touch my stuff, or I will call the police." The fear, he nowhere alleges any fear that he had of physical harm from the plaintiff. And that when read in context, he didn't. I mean, that was in June 22nd, 2019, Your Honor. This 209A order was filed in sometime in 2020, I believe.
Do you think the judge could have found that the defendant was delusional?
Possibly. I mean, I don't think she made that finding. She may have believed that, but I don't think that alone is the basis for entering a 209A order.
Do you think that she could have found that her belief that the plaintiff had sexually harassed her, I'm trying to remember what else it was that had done physical violence to the door of her room, that those were delusional beliefs? Do you think the judge could have found that?
I suppose she could have. I mean, if you're asking me if she could have found something, she didn't
Well,
make
do you
that
think it would have
finding.
been, do you think it would have been supported?
I don't think so. I don't think that would have been delusional. It's not, it's clear that there was some friction between these occupants of the apartment. I don't think it's, you know, that is so far-fetched to say that's delusional. Maybe not credible, perhaps, but I wouldn't say delusional, no.
So considering that she testified that she's working for the CIA and the FBI and Joe Kennedy and all the things she said, she testified to under oath, how could a judge not be entitled to find that she's delusional?
Well, whatever the judge's beliefs were, I don't think, you know, whether somebody has delusions or not doesn't necessarily bear on the question of whether they pose a threat of physical harm to anyone.
Would you agree that someone getting in your face and yelling at you, if they're just a hothead, is a little different than someone getting in your face, yelling at you, saying they're calling the police when they believe that they are working for the CIA and the FBI and have uranium from General Electrics? Doesn't that change what is a reasonable person would fear in that circumstance?
No, I don't think so, because if a judge thinks that's, you know, that working for the FBI is delusional, you know, very well, you know, that could very well be thought delusional by the person who's hearing that statement. I would also add that all this
Isn't it reasonable to fear that a delusional person will take violent actions that a non-delusional person wouldn't?
I absolutely disagree with that, because all that depends on what the nature of the delusions are and what the context of what the delusional person's conduct and speech are. You know, if a delusional person says, you know, I believe you're trying to kill me, therefore I'm going to lunge at you with a knife, it's a totally different story. If a delusional person just says, well, you know, I have secret connections to the President of the United States and very powerful people.
If a delusional person believes that parking close to her car amounts to sexual harassment, and if she feels that her claims of sexual harassment have gone unaddressed by the authorities for a long period of time, is that enough to then fear that she may take things into her own hands?
I don't believe so, Your Honor, not even close. You know, whatever private subjective beliefs, delusional or not, unreasonable or reasonable, that the defendant may have had, if they don't relate to actually threatening any physical harm on the plaintiff, they cannot support the issuance of a 209A order against her. I mean, the 209A order is a very blunt tool. And, you know, I've heard the saying that you've got to use the right tool for the right job. The 209A order, you know, is not the right tool for this job. That's not to say that, you know, the statements or conduct attributed to this defendant or in other contexts might be actionable under some statutory or common law theory other than 209A.
For example,
defamation or whatnot, possibly.
No. I'm not talking about the telling third parties. What is the correct tool? I mean, is it involuntary commitment? Is it calling the police? What should the plaintiff? I assume it's not. I assume, maybe I'm wrong, that there's something wrong with what the defendant, if the plaintiff has believed what the defendant was doing, threatening, calling the police repeatedly and threatening to have a legal immigrant deported based on false calls to the police. Well, I guess I'd ask two questions. First of all, might that result in physical force being used, wrongly used against the plaintiff? Calling ICE to come and deport him? Might he reasonably fear that hands were going to be put on him as a result of that?
I don't believe so, Your Honor. If that was, you know, if that fear, if he had that fear, assuming he did, I mean, he says that he did, but first of all, even if those allegations, even if the conduct where, you know, the defendant was calling ICE, to ask them to investigate the immigration status, that would be constitutionally protected petitioning activity. Whether, whatever his immigration status is, whether it's legal or illegal, asking ICE to investigate whether somebody.
But falsely alleging crimes, calling the police and trying to get them to come when all he's done is move her dishes out of the sink or something. So it's, it's protected activity, that's fine, but it's a false claim designed to get him deported or put in jail, as she said.
Okay. There may be a claim for abusive process. There may be a claim possibly by the landlord who, appears to have had some involvement in organizing this legal proceeding and initiating it. Maybe a claim for breach of quiet enjoyment and, bringing an eviction action. But the 209A, order is not a means to take a shortcut around and circumvent the eviction summary process procedure because a tenant is not getting along with other people in the apartment.
The relief he wanted was for her to keep what he described as a safe distance between them. That's what he asked for. I'd like her to stay a safe distance away from me. And none of what you're describing does that. That's what a 209A does. But of course, only in the narrow circumstances where there's a reasonable fear of imminent physical harm.
Which is not present here, Your Honor. And it's an objective standard that your case law makes that very clear. It's an objective standard. Simple, unpleasant interaction, vexatious, disputes that are verbal, territorial disputes. If they're not accompanied by a reasonable fear of physical harm from the defendant, they cannot support the issuance of a 209A order. And I see my time is up. If there are any more questions, I'll rest on my brief, but I will.
Justice Ditkoff,
I do have one. I noticed the order was vacated a few months ago. Do you agree that your complaint about the prior restraint on speech is now moot under Quinn?
That's a good question. I hadn't thought of that. You referred to the case of Quinn. Can you give me the full name of that case?
You cited it.
I cited it. Okay.
In footnote 1.
Let me think about that 1 minute. It might be moot, Your Honor. It might be moot. However, I believe this court should exercise its discretion and address that issue because it's an important issue. It's an issue that almost certainly will arise in the future. And from practicing in the district courts, I can tell you it does arise frequently in the district court in 209A proceedings, and it will provide, your guidance will provide help to the district court judges in balancing those interests.
All right, your time has expired. Very good argument. Thank you. Very helpful to us. Very interesting and difficult case. It is submitted.
Thank you, Your Honors. Have a good day.
Thank you.